items for pronouncement of judgment. Item number 33, RSA 15 of 2011.
Appeal dismiss.
Item number 34, RSA 241 of 2014.
Appeal dismiss.
Item number 35, 2600 of 2024.
Bail petition dismiss.
Dismission.
Yes.
This is the condemnation petition of 2023, not yet disposed of. It may kindly be listed on 30.
On
No,
6th,
Condemnation matter, 2023, it is pending.
30 already.
4th of
On
November.
4th.
4th of
On 4th.
November.
Relevant. Alright.
My lord, we have filed an IA that we are agreed to settlement of MSc appeal number 130 of 2024.
Hmm.
We have filed a settlement IA for this. So maybe it will list it on 5th November. My lord, I have some MSc appeal which is pending from 2021 and not listed till today. So maybe listed on 5th November.
How many cases are there?
Yeah, my lord, there is two is from 2021 and there is 2 of 2000.
Not on the same day, on different dates.
Okay, my lord, 5th November.
Take a date from him.
Yes, my lord.
I would like to mention, I am for listing of orders of the CRP, my lordship, CRP IO for orders.
When?
My lordship, next week.
On 6th November.
6th. Orders, my lordship.
May I please, your lordship? I'd like to mention for listing on RSA, my lord. RSA, my lord, regular second appeal. Can it be listed on first week of November, my lord? 2012, madam.
For hearing?
Yes.
For hearing?
Yeah.
November last week.
Then any date?
26th November.
In item number 1, I have gathered the instruction. What has happened, the substitution application is still pending. The respondents have not been able to establish their right to continue the suit. Therefore, lordship, next date is 21st. Lordship. Therefore, this matter may be taken up after the application of substitution has attained finality. Therefore, any date after 21st November.
After?
21st November, the next date.
Kobe?
On 29th.
On the pair being made by Mr. Bora, learned counsel for the petitioner, recess shall list the matter on
29th November.
Deeply.
May I please, your lordship? My lord, I beg to mention item number 3, my lord. My lord, this matter may kindly be adjourned for 2 weeks, my lord, because my senior is out of station.
On the pair being made by Mr.
TC Das.
TC Das, learned counsel for the petitioner, recess shall list the matter after 2 weeks.
Please, your lordship.
Yes.
I'd like to mention 2 matters, lordship. One is IS filed for striking of the name of one of the respondent from an RSA disposed of. And another CRP IO for motion, lordship. Both are filed in the month of September, not listed either on 4th or 7th, your lordship, because I'll be out of station. On 4th, it will be beneficial for me.
Possible.
One matter on 4th, another matter on some other date.
7th in that.
Okay, 7. Not 8. 8. One on 4th, one on 8th. Okay.
Lordship, MSc appeal of 2022, last listed on 27th, 22 July. Yes, it is for order. It may be listed on 4th November.
On 6th. On 6th, not 4th, on 6th.
4th, no?
On 6th. On 6th November.
6th.
On 4th, we have many cases.
May I please, lordship, I'm prayer for listing MSc appeal, lordship. Lordship, kindly listed on 5th November, lordship.
For hearing or order?
Admission. Yes.
May I please, your lordship, item number 2. Senior counsel leg has broken. A leave note is there, right? Serial number 12. So kindly 2-3 weeks maybe I'll grant it.
On the pair being made by Mr. Your good name?
SK Bhattacharya.
SK Bhattacharya, learned counsel for the petitioner, recusal is the matter after 2 weeks,
After 3 weeks.
3 weeks.
May I please?
Mm.
Look, I just to mention for listing a CRP, it
Mm.
is listed on 4th November.
In which
For
column?
orders.
For this,
Yes, Lord. Sir.
fourth, possible.
On 8 November,
Lord, sir. Most of.
May it be the lordship,
Mm.
two CRP IO matters lordship may be listed order columns convenient to your lordship, any date lordship.
orders
Or service.
on
report date,
11th and 13th. One on 11th, one on
Both
13th.
can be on 11th your lordship.
Okay.
Obliged. lordship.
For motion item number 4,
Lordship, matter relates to lordship delay in filing lordship. Beyond 6 months time lordship.
Mm.
In similar cases, lordship have directed us to take instruction regarding when the FIR was forwarded to concerned tribunal and whether the case was listed, when the tribunal.
In another case.
In another case.
Mm.
This practice same lordship,
Mm.
that they had filed a case after 6 months.
Mm.
As per new act lordship, it is required to be filed within 6 months from the date of accident.
Mm.
It was filed beyond that period, lordship. We had filed one petition, but that petition.
No, here the fact is quite different. The accident took place before the new amendment came into force,
Yes, lordship.
right?
Accident took place before coming into that act, lordship.
Yes.
But even after that, lordship, it was filed after lordship. More than lordship, accident lordship on 18/10/2017 lordship.
Mm.
And the case was filed on 18/4/2023. The
Mm.
new act came into force from 1/4/22.
Mm.
From that
So
point,
since the accident took place before coming into force of the new act, the old act will apply there.
lordship, our submission is that lordship, when new act came into force, lordship,
Mm.
so from that time, lordship.
No. There is one judgment of Madras in Kerala High Court.
Our lordship reading is that lordship, after 1/4/2023.
No.
All cases have to be filed within 6 months, lordship.
Mhm.
And it was filed long after that period, lordship.
No. There is no time limit in the old act.
All act, there is no time limit, but
Mm.
lordship, after coming into force of that
No,
new
no,
act,
no.
all acts are not, provisions of all act are not applicable, lordship. That is our contention.
If so, you show me the provision, we will take it up at 2 o'clock.
number 5,
Okay.
May I please, Your Lordship?
Yes.
My lord, the petitioner is the defendant number 3 in the suit.
Mm.
The respondent filed a suit for a declaration and recovery of possession of 5 acres of land.
Mm.
The case was contested by the petitioner defendant number 3. She
So
was a old
here
lady,
the evidence of the petitioner was closed.
closed. My lord, what happened is this,
Mm.
the petitioner defendant number 3, she is a old lady now, more than 80 years.
Mm.
Therefore, she prayed before the court to examine her on commission.
Mm.
The prayer was allowed.
Mm.
But the commissioner, he is not examining the petitioner in her residence or any other place.
Mm.
Therefore, she made a.
No,
the
no,
petition-
her evidence in chief was recorded.
the evidence and affidavit she has filed,
Mm.
cross-examination.
Mm.
The cross-examination was not recorded by the commissioner.
Mm.
Thereafter, she made an application before the court,
Mm.
which I have, order sheet I have annexed. Your lordship kindly turn to page 52. Both sides are represented learned counsel for the defendant number 3. Defendant number 3 is the petitioner hearing. Was verbally informed that defendant number 3 has not yet examined. The advocate Suvalra is appointed the advocate commissioner to record the evidence of DW3 as per order dated 14/3/2019. Both the parties and advocate commissioners are directed to coordinate with each other for recording the cross-examination. Thereafter, this commissioner was not examined. Therefore, on our request, the advocate commissioner was changed. Another advocate was appointed. That advocate on 6/8/2024 informed the advocate of the petitioner that he is going to cross-examine the petitioner on 7/8/24. Only on such a short date it was not possible. Therefore, the examination could not be completed. Moreover, the defendant number 1 and 2 also paid for time. But the commissioner appointed by the court, he has failed to do the mandate of the High Court, the rules, High Court rules. Therefore, the commissioner's report, your lordship kindly see, page 64. With reference to the above, I would like to state, report the commission that appointing commissioner in the reference case was fixed as 2 dates on such and such. On Thursday, on 31st July, the learned advocate for the defendant informed that the witness is hospitalized as indoor patient, and on the next date, 6/8/24, the defendant side is unable to appear before the commissioner for the personal inconvenience of the commissioner and could not be done. Therefore, your honor will please to extend the time for the commissioner report. Our advocate, the advocate for the defendant number 3, also filed a petition. That petition was at page 66. The advocate for the defendant number 3 most respectfully states that the above noted case was fixed for report on the commissioner. Srimati Brajabala Hazarika DW witness is an old bedridden witness for cross-examination should be done at her home in commission by the commissioner Sri Kundal Saikia. Sri Kundal Saikia this morning, that is on 7/8/2024, informed the petitioner that the petitioner advocate for executive commission today, but it is not possible to take evidence within such a few hours in a bedridden situation. Therefore, your honor will please to pass extend it. But I am aggrieved by this by the order dated the commissioner, whether your lordship kindly see the rule 224 of High Court rules and order.
Go ahead. High Court rules and order.
224.
High Court rules and order. In civil court rules and order.
Your lordship can take these also.
High Court.
Here it is written that the commissioner has to inform in writing 1 month prior to the examination. He informed on 6/8 that the cross-examination will be done on 7/8.
You are referring to rule?
224. the commissioner is to issue notice to the parties. So but here is no notice was issued. On 6/8/24, he told it tomorrow, the cross-examination will go. But there is no written notice to the council or to the parties. And my lord, on this ground, the learned trial court closed the evidence on, closed the cross-examination of DW3. And the evidence on affidavit filed by petitioner, that was expunged. That cannot be expunged because the petitioner, defendant number 3 is in no fault. Why this her evidence on affidavit will be expunged? The court may engage another commissioner to cross-examine. The cross-examination cannot be closed, and my evidence on affidavit cannot be expunged because it is not my fault. It is the fault of the commissioner. He informed on 6/8 that on 7/8 cross-examination is there without following that rule 224. Because if my evidence on affidavit is expunged, then I have no case. Though I find it in statement.
So one date will be sufficient for you?
2 days ago, he's an old lady now, he is more than 80 years. She is more than 80 years. 2 days will be necessary. Or the commissioner has it been picked.
Heard Mr. S.A. Sharma, learned senior counsel, assisted by Mr. Learned counsel for the petitioner. This petition under Article 227 of the Constitution of India. The petitioner has put to challenge the correctness or otherwise of the order dated 7th of August 2024, passed by the Learned Civil Judge Junior Division number 1 in titles of number 75 of 2015. It is to be noted here that by the impugned order dated so and so, the Learned Trial Court refused to extend time to the commissioner engaged by him and appointed by him for examination for recording cross-examination of DW3, and thereafter thereafter dispense with the cross-examination of DW3 and expunge the evidence in affidavit submitted by DW3. Mr. Sharma, learned counsel for the petitioner, submits that the respondent herein as plaintiff institute a suit against the petitioners in the court of Munship number 1 Nagaon, being title suit number 75 of 2015 for a decree of declaration of right, title, interest, and recovery of possession and other relief. In the said title suit, the petitioner has submitted written statement and made a prayer for recording her evidence on commission, as she is an old lady of 80 years old and bedridden and unable to attend the court. Thereafter, the Learned Trial Court has allowed the pair for recording evidence of the DW3 on commission. But the learned, due to some reason, the commissioner could not record the evidence cross-examination of DW3, for which as an extension of time for submitting commission report was sought for, but the Learned Trial Court, by impugned order dated so and so, has refused to extend the time, and thereafter Thereafter, dispense with the cross-examination of DW3 and expunge the evidence of DW3. Mr. Sharma submits that the impugned order suffers from illegality and also from arbitrariness in the the learned trial court has not extended the time for cross-examination DW3 for no fault of her and also expands her evidence. And instead of appointing a new commissioner, the learned trial court has chooses to dispense with the evidence of DW3, for which prejudice is caused to her, and therefore Mr. Sharma contented to set aside the impugned order and to grant time for cross-examination of DW3. Further, Mr. Sharma, referring to Rule 224 of the Civil Code Rules and Orders of Guwahati High Court, submits that before examination of the witness on commission, 1 month notice has to be given. But in the case in hand, the learned commissioner appointed by the learned trial court has fixed the date on 7. Fixed the date for examination of the DW3 on 6/7/2024, fixing it on 7/8/2024. And on such count also, the impugned order so passed by the learned trial court fails to withstand the legal scrutiny. But having heard the submission of Mr. Sharma, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed in record, and also perused the impugned order dated 7/8/2024. It appears that the learned trial court, by the impugned order dated so has refused to extend time to the commissioner for examination of the DW3 and dispense with the examination of DW3 and also expunge her evidence. But it appears from the impugned order and also from the documents placed on record that it was not the fault of the petitioner hearing for non-recording of her evidence on commission by the commissioner appointed by the learned trial court. Further, it appears from the Rule 224 of the High Court Civil Rules and Order that 1 month notice has to be given before examination of the witness on commission basis, but no such notice has been given to the witness concerned. Thus, having examined the impugned order in the light of the aforementioned facts and circumstances, and also in the light of submission so advanced by Mr. A.C. Sharma, learned counsel for the petitioner, this court is of the view that the impugned order fails to withstand the legal scrutiny, and on such count the same requires interference of this court. Accordingly, the same stands interfered with and set aside, and the learned trial court is set aside and course, and the learned trial court is directed to whether the earlier commissioner will continue or new commissioner has
The
to.
court, trial court will decide. Where,
Directed to afford opportunity to the commissioner to cross-examine the petitioner and the said process has to be completed within a period of 2 months or period of 2 months from today. In terms of this CRP is that IO is disposed of in the motion stage itself. নতুন MBA-টো হেৰিয়াত অহাৰ আগতে 2017 এটা কেছ আছিলে। কেছটো ফাইল কৰি আগতে নতুন MBA-টো হেৰিয়াত অহাৰ পিছত
Maybe. The instant petition has been filed challenging the order dated 30/9/2024, which is at page 45 annexure B. The present respondents has filed them as case under Land Grabbing Act. Along with the main case, they have filed on petition under order 39/1 and 3. And on the day of entertaining the said petition, as well as the LG case, my lord, the impugn order has been passed 39, which is at page 45, my lord.
Yes.
The basic grievance of challenging this particular order is such. The learned trial court below has granted the ad interim measure, the main relief. The main relief has been granted in the as ad interim measure, which cannot be given. And that too on the very first.
So does it mean that the court is not entitled to grant temporary injunction,
Temporary-
ad interim injunction?
I have two grounds. I am one of the co-sharer. I have annexed the patta, which was issued in my predecessor's name. Lordship may take into consideration page 54. In the year 1979, my lord, patta was issued in the name of predecessor in interest of the present respondents as well as the present petitioners. I am the co-sharer of the said suit patta and suit dag, my lord. Now question arises, when I am possessing my own land, my lord, instead of they have filing the partition suit, they have filed a land grabbing case, my lord. That too, my lord, the main relief has been granted at ad interim measure, which cannot be made. And I have decided, my lord, a decision to that effect, my lord. Our High Court has decided that main relief cannot be granted as interim relief. Supreme Court has also, my lord, decided as such, my lord. So in this regard, my lord, what happened, my lord? The learned trial court below has now tried to execute the injunction order as if the main relief has been going to be executed by way of this man, which cannot be made without my lord trial, my lord. That too, we have not filed any objection in that regard. Issues are to be framed, that are to be decided, evidence are yet to be laid, my lord. Without deciding all these issues, my lord, the learned trial court below is going to execute what they have prayed for in the main case, my lord, which cannot be made. We are prejudiced from all aspects, my lord. I have annexed the copy of the petition of the, my lord, page 34, my lord.
Yes.
Relief part is at, my lord, page 42, starts from page 42.
Yes.
Very good. It is therefore prayed that your honor may be pleased to pass an order of temporary injunction, ex parte restraining the prohibiting opposite parties, respondents and all other persons acting, claiming under or through them from doing any sorts of act, deeds and things which judiciate to the interests of the applicants by way of creating a disturbance of interference to the applicants in exercise of their right and receivable position over in respect of the suit property, not to create any hindrance to the applicants in giving the boundary fencing and to direct the officer in charge Tinsukia Police Station to ensure the enforcement of the said injunction order in its true spirit and in case of any disobedience thereof, and after hearing the parties, further be pleased to pass an order to make the said expert injunction order as absolute. Now, my lord, operative portion of the impugn order at page 52, madam. Third paragraph. Page 50. Hence, to preserve the subject matter and for the purpose of proper adjudication of the case in hand, an expert ad interim injunction is granted in favor of the petition by restraining the opposite parties and all other persons acting, claiming under or through them from entering into the suit property or any part thereof, and from doing any sorts of acts, deeds, and things prejudicial to the interest of the petitioners, by way of creating any disturbance or interference to the petitioner in exercise of their right and receivable position over and in respect of the suit property, and not to create any hindrance to the applicants in giving the boundary fencing, and to direct the OC of the Tinsukia PS to ensure the enforcement of the said injunction order in its true spirit. Now, my lord, that particular portion has going to be executed by the learned trial court. If any violations in there, my lord, provision of order 39 rule 1 and 2, particularly rule 2A is there, my lord. If I violate anything, my lord, that has to be proved in accordance with law. But ad interim measure, the main relief cannot be granted. This is the principle of law, my lord, settled by the Honorable Supreme Court as well as this Honorable High Court. I have given the matter citation.
That's all right, but in order to get relief of this temporary injunction,
My lord.
such a pair must be there in the main
Yes, yes.
suit itself.
I am not denying that they cannot play.
Hmm.
They can play in the temporary injunction. On the day of issuing notice, my lord, that's main relief has been granted.
No, this
On
is
the
a
day of-
temporary injunction.
Well, temporary injunction till the disposal, but when temporary injunction is granted, my lord,
Hmm.
it has to be hard. I am not hard, my lord. I am not hard. Notice was issued on that particular day. I yet to appear in the learned trial court below, yet to submit my written objection. After hearing both the sides, my lord, the temporary injunction, petition for temporary injunction can be disposed of. Either it can be dismissed or it can be allowed. Then, my lord, main relief,
No, but you tell me whether this petition would lie,
so far,
because there is provision for appeal against the granting of injunction.
yes, my lord. So far, they have filed a case under Land Grabbing Act.
Hmm.
There is no, my lord, appellate court tribunal has been formed as on date, my lord.
Hmm.
So we have to approach this honorable court by way of Article 227 of this constitution.
Hmm.
They have filed a case under Land Grabbing Act. Along with that, my lord, learned tribunal has passed the injunction order, my lord. I have no option approach by way of filing to 227.
Hmm.
Had it been passed by the learned civil judge, my lord, my petition would have been a different one, my lord. It was passed by the learned tribunal under Land Grabbing. That is why, my lord, 227. Now, my lord, what happened on 21st of, my lord, October, my lord. Next date was fixed on 21st of October. On that day, I have filed this case.
Let notice go at this.
My lord, no, my lord. Otherwise, my lord, if the injunction, ad interim injunction is executed, nothing is to be, my lord, adjudicated at this stage. Nothing is to be adjudicated. Because we are possessing the suit land.
Okay.
We are co-sharer, my lord.
Okay. Heard Mr. Sharma, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 30/9/2024 passed by the learned tribunal. No, this is a passed by the learned additional district judge.
My lord, he is, my lord, sitting as a judge of the tribunal. Land Grabbing case, my lord. Yeah. He has the jurisdiction.
Hospital learned additional district judge Tinsukia in land grabbing case number 12 of 2024 under Assam Land Grabbing Prohibition Act 2010. Mr. No, it is to be noted here that by the impugn order dated so and so, the learned tribunal has granted temporary injunction. No, ex parte ad interim injunction in favor of the respondent hearing. Mr. Sharma, learned counsel for the petitioner, submits that the respondent number 1 in a representative capacity has instituted a land grabbing case number 12 of 2024 under the Assam Land Grabbing Act before the learned additional decisions Tinsukia in respect of a plot of land measuring 1 bigha 1 kotha 14.66 lasers covered by DAG number 161 of periodic patta number 31 situated at Tinsukia town. And along with the said case, the respondents herein have also filed on Ms. J case number 24 of 2024 under Order 39 Rule 1 and 2 CPC for temporary injunction. And thereafter, the learned trial court has granted the relief, which is the relief being sought for in the title suit. And now going to execute the aforesaid order with the help of police force, and that the petitioner is aggrieved because their forefathers' names were reflected in the periodic Kheraspatta since the year 1977.
1979.
77 or 79?
79, my lord. Patta was issued on
54. You come to page number 54.
my lord. 54 is the my lord patta. My lord, date was at 56, my lord. Date of issue, my lord. 1/8/1979, my lord.
18.
1979.
Page number
56, my lord.
and that the respondents herein, instead of filing a partition suit, have instituted this land grabbing suit against the present petitioners. And if the impugn order is executed, then serious prejudice will be caused to the present petitioners. And therefore, Mr. Sharma had contended that the impugn order dated so and so may be stayed. Having heard the submission of learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on record and also perused the impugn order dated so and so. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. And considering the submission of Mr. Sharma, learned counsel for the petitioner, and also considering the facts and circumstances on the record, this court is of the view that a prima facie case for staying the impugn order is made out, and accordingly the same instance state till returnable date list after 4 weeks.
Highly
Item number 7.
May I please answer? In this case, petitioners, people lordships are the degree holder in the title execution case. filed by them. The case is a long history. Although issue in this petition is limited lordship, there's a long history. What happened? All the decree holders filed the execution case. Thereafter, the legal heirs of defendant number 2, they filed an application under section 47 of CPC. We filed objection to the this petitioner number 1 to 4 in the on behalf of all the degree holders. Now, learned court below then heard the matter on 2 occasions, then issued notice to the sum of the degree holders. The input order is page 165.
So what wrong with the order of
No,
the?
All the degree holders are represented in the school. Copy was furnished. Objection has been filed. So, course was to,
Objection was filed in title execution suit.
yes, objection means they filed this application under section 47 of the CPC. We filed objection against them. All the degree holder has not signed, but some of them have signed, and it was filed on behalf of all. Now, then issue has been, notice has been issued to the again degree holders. We are represented there. It is only delaying the process. Page 158 is our objection version.
One,
158. Objection of the degree holder also.
where the court has issued notice.
Page, court has issued notice to hard land council petition has been submitted before the court, the defendant number, on the basis of the their submission, judgment letter submission, that such and such, there is number, some number is given, they are not represented. It is not correct. No. The execution case is also, I have annexed the execution petition. The original is page 124.
No, if a party remain absent without step on a particular date, is it not necessary to issue
No,
notice?
Lordship, may I please the execution petition?
Mm.
All the degree holders have signed it. All the degree holders, they are represented by one council.
Mm.
So, their further notice is not required. They are represented in the suit. It is delaying the proceedings. It is almost 50 years. 2 occasions it went up to Supreme Court. I have annexed all this. I can, and the issue raised in the 47 petition is also already decided by the Supreme Court. They cannot raise it again. Now at page 165, it has been notice has been issued. We are all represented there. Only thing is that in objection, only 4% has signed. They have signed for filed this objection for all. Nobody is prejudiced. We are on the same. How they are? They have filed this petition is okay. Now, when there is an objection, the next course is to hear the objection, hear the petition, and dispose of it. And page 162, Lordship, kindly come to page 160, 162. This is the first order in this, after they file this petition. That is furnish the copy to the other side. We are decree holder, we filed the execution petition. We are all along represented in the case.
What is the pair in the 47 petition?
47 petition, it is at page 128. Where part is page 153, 153, 155. It is therefore stated that Your Honor would be pleased to dismiss the above execution case with cost or in the alternative to appoint an Amin Commissioner and at the cost of the JD petitioner to investigate the decretal rule with reference to the description as mentioned in the schedule of the decree and below schedule one premises of the petitioner JDs where they have been operating the businesses aforesaid and to locate identify the decretal rule and to submit a report according to the court taking into consideration the objection raised herein above, and your honor may further be pleased to dismiss the above execution case. The impugned decree itself is null and void, known as such. Now, if I may take your lordship to the, it is a history from the beginning, lordship. Lordship may kindly come to page 22. The suit was filed in 1977 in respect of a suit provision, which is suit from under Urban Areas Rent Control Act. Page 22, lordship.
Can you show me that the issues raised in the 47 petition has already been adjudicated by the Supreme Court?
Yes, lordship.
Where?
Yes. They are the parties, judgment debtors who have filed these 47 petitions. They were defendant number 2. That is what I am showing you, lordship. Defendant number 2. They are legal heirs of the defendant number 2. They have filed written statement. So their claim is same. They have filed written statement at page 27. Their written statement.
So that's all right. You show me where the Supreme Court has dealt with the issue raised in this petition under
Yes, that is what I am saying.
Section
lordship.
47.
What happened, lordship? In the trial court, our suit was dismissed. But trial court held that there is landlord-tenant relationship with the defendant number 1. We filed appeal. Appeal was also dismissed. We filed revision. Revision also dismissed. And the revision in the both the first appeal and the revision, both the appellate court and the Honorable High Court discussed. They are part of this. The question has been raised in this 47. Now we went to Supreme Court. Honorable Supreme Court, page 46. Is there? Judgment also. And page 49, also look at page 49. There is an issue, then paragraph 8. May I please read? Parties adduce their evidence. The trial court by judgment in decree dated 23/12/99 dismissed the suit. So far as issue number 1 is concerned, the trial court answered in favor of the plaintiff by holding that the suit is maintainable. So far as the issue number 2 concerned, it was also answered in plaintiff's favor by holding that the suit is not bad for non-joinder of the necessary parties and maintainable. So far as issue number 3 is concerned, it was answered against the plaintiff by holding that there was no cause of action to file suit. So far as number 4 is concerned, it was divided into 2 parts. So far as the first part it is concerned, it was answered in plaintiff's favor, wherein it was held that the defendant number 1 was the plaintiff tenant in respect to the suit premises. In other words, it was held that the relationship of landlord and tenant is established between the plaintiff and defendant number 1 in relation to the suit premises. So far as second part of the issue number 4 is concerned, it was held against the plaintiff by answering that the defendant number 1 is not a defaulter in payment of rent to the plaintiff. By answering those 4 issues, the trial court dismissed the plaintiff's suit. Paragraph 9. The plaintiff felt aggrieved and filed first appeal before civil judge number 1 Silchar, Kachar being title amendment number 4. It is pertinent to mention here that the defendants did not file any cross objection under order 41 rule 22 of the Code of Civil Procedure, hereinafter referred to as the court, against any of the findings recorded by the trial court against the defendants in the appeal. By the judgment dated 14/8/2002, the first appellate court dismissed the appeal. The plaintiff felt aggrieved and filed revision in the Guwahati High Court. By impugned order, the High Court dismissed the plaintiff's revision and affirmed the judgment of the first appellate court, which gives rise to the filing of the present appeal by our special repetition by the plaintiffs in this court. Paragraph 12. After hearing the learned counsel for the parties and on perusal of the record of the case, we are inclined to allow the appeal in part, and while setting aside the impugned order and also the judgment of the first appellate court, remand the case to the first appellate court for deciding the first appeal on merits in accordance with the law as directed herein below. 13. In our considered opinion, the need to remand the case to the first appellate court has arisen for more than one reason as mentioned herein below. First, the first appellate court committed a jurisdictional error in deciding the legality and corrections of the first part of the issue number 4 on merits. Mere perusal of the judgment of the trial court would go to show that while answering the issues, the trial court had divided issue number 4 in two parts. So far as the first part is concerned, it was in relation to the question of whether the defendant number 1 was the plaintiff's tenant or not. In other words, it was in relation to the question whether the plaintiff was able to prove the relationship of landlord-tenant between him and the defendant number 1 in relation to suit premises. Indeed, this was one of the main questions involved in the suit. This question, that is the first part of issue number 4, was decided by the trial court in plaintiff's favor, wherein it was held that defendant number 1 was the plaintiff's tenant. So far as the second part of the issue number 4 is concerned, it was in relation to the question as to whether defendant number 1 was the defaulter in payment of rent to the plaintiff. This question was answered by the trial court against the plaintiff, and in defendant number 1's favor, wherein it was held that the defendant number 1 did not commit any default in payment of rent to the plaintiff. It is for this reason the suit was dismissed. The plaintiff in his first appeal did not challenge the finding of the trial court recorded on the first part of the issue number 4, and rightly so, because it was already answered by the trial court in his favor. The first appellate court therefore could not examine the legality and correctness of this finding in plaintiff's appeal unless it was challenged by the defendants by filing cross objection under 41 Rule 22 of the court in the appeal. As mentioned above, the defendants, though suffered the adverse finding of the first part of the issue number 4, did not file any cross objection questioning its legality. In the light of these admitted facts arising in the case, the first appellate court had no jurisdiction to examine the legality and correctness of the findings on the first part of the issue number 4 in plaintiff's appeal. Second, High Court also committed the same mistake by not noticing the aforesaid jurisdictional error committed by the first appellate court. The High Court in the plaintiff's revision again went into the legality and findings of the first part of the issue number 4 on merits and affirmed the finding of the first appellate court. This finding ought to have been set aside by the High Court only on the short ground that the first appellate court had no jurisdiction to examine in the plaintiff's appeal. Now, in our opinion, the High Court should have noticed the aforementioned mistake and remanded the case to the first appellate court for deciding the plaintiff's appeal afresh on merits, confining its inquiry by the first appellate court to decide only the legality and correctness of those issues which were decided by the trial court against the plaintiff and which led to the dismissal of the suit. In our opinion, in the light of the above, light of what we have held above, we have no option but to set aside the appeal order and also the judgment of the first appellate court and remand the case to the first appellate court to decide the first appeal filed by the plaintiff afresh on its merits only. So, all the questions they have raised in their written statements and argued before first appellate court and revisional court has been nullified and said, and para 22 lawsuit. We, however, make it clear that since the defendants did not file any cross objection in the appeal under Order 41 Rule 22 of the court, they are not allowed to file the cross objection at such belated stage, taking advantage of the remand of the appeal to the first appellate court by this court. Thereafter, remand, appeal was heard again, appeal was allowed. Then they filed revision, the revision was dismissed. They went to Supreme Court, it was also dismissed. The order of Supreme Court. Page 115. The petition is dismissed. Therefore, their plea taken in the written statement was never considered.
Okay. Heard Mr. S.D. Purkasto, learned counsel to the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner have put to challenge the correctness or otherwise of the order dated 28/9/2024 passed by the learned civil judge junior division number 2 Kasar. This to be noted here that by the impugn order dated 28/9/2024, the learned Munship number learned civil judge junior division number 2 Kasar Silchar has directed to issue notice to the absentee defendants and also kept Miss J case number 138 of 2024 in abeyance.
59 or 23 also.
Title execution 55 of 2023. Mr. Protest or learned counsel for the petitioners submits that the petitioners are degree holder in title execution case number 55 of 2023, arising out of title suit number 189 of 1997. Mr. Purkaisto further submits that after getting the degree in title suit number 189 of 1977, the petitioners have instituted one title execution case number 55 of 2023. On 12/8/2024?
Yes, Lordship, it is
No.
filed
No,
on
no.
3/8/23, Lordship.
When?
3/8/2023.
Page number?
Page number is page 124, but date is filed on, it is written by hand in the left side, Lordship, page 124.
P8/2023. Where is the first order of the executing court?
That is not a have annex, Lordship, this is only I annex their petition, this is section 47 petition, which was registered as 138/24.
And during the pendency of the site title execution suit, the petition on the respondents herein. No. Oh yes, the respondents herein have filed one petition.
Page 162, Lordship, will find the order.
Filed one petition upon which Ms. J case number 138 of 2024 has been registered. কি বলে কোনো লাইনটা? Filed a petition under section 47, read with section 151 CPC upon which the learned court below has registered a Ms. J case number 138 of 2024. And therefore, in the said petition, the present petitioners have filed objection. But the learned executing court by impugn order dated 28/9/2024 has directed to issue notice to the absentee defendants and also kept the title execution case number 55 of 2023 in abeyance. Mr. Purkaisto submits that the issues raised in the petition under section 47 read with section 151 CPC has already been adjudicated by Honorable Supreme Court, and as such, there is nothing to be adjudicated in the said petition, and the said petition has to be dismissed by the learned trial court and to execute the decree. But instead of doing so, the learned trial court has directed to issue notice to the absentee dependents who were all along represented by their engaged counsel. and thereby cause delay in disposal of the execution case. And as such, the impugned order so passed by the learned executing court suffers from illegalities and arbitrariness, and therefore it is contented to set it aside. Having heard the submission of Mr. Purkasto, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record and also perused the impugned order dated 28/9/2024. And also gone through the petition number 9 to 7 of 2024 under section 47, graduate section 151 CPC, and the objection filed by the present petitioners dated 31/8/2024. It appears that the title suit was instituted in the year 1977. And since then, several years elapsed, and ultimately the same was decreed in the year when the decree was passed.
Finally, Lordship, in High Court, it was
No, the decree by the trial court.
no, it is into title appeal 31/3/2022. Appeal was allowed. 31/3/2022. Appeal was allowed after
Page number
page 81. Page 96 is the order.
and the suit was decreed by the first appellate court by judgment and ordered and judgment and decree dated 7/3/20 no
31/3.
31/3
31/3/2022.
2024
22.
2022.
Thereafter, they filed revision.
Further, it appears that against the said judgment and decree dated so and so, a revision petition has been preferred before this court, and the same was dismissed by this court by order dated
Order dated Lordship 23/5/2023.
23,
5/2023.
page number
Page 98 and 105. CRP 67/2022. Page 19 is the first page. And relevant question 23/5. Page 105.
in CRP number 67 of being CRP number 67 of 2022 by judgment and order dated
23/5/2023.
2023. And thereafter,
They filed SLP.
the respondents herein have preferred one SLP before the Honorable Supreme Court, and the same has been dismissed by order dated
19/7/2024.
page number
115.
Nineteen 7/2024 by in SLP number SLP
Leave to appeal civil.
in special leave to appeal within bracket C number 27393 of 2023. That being the position, the judgment and decree dated passed by the dated. What is the date of the
Appellate court 31/3/2022.
attain finality, and thereafter the petitioners herein have instituted the execution proceeding. being execution case number
55 of 2023.
55 of 2023. In the said execution proceeding, the petitioners have filed on petition.
Not petitioners, lordship, judgment debtors.
No, yes, the respondent's hearing, being judgment debtor, has filed on petition under section 47, read with section 151 of the CPC.
We filed objection against that.
And the present petitioners have filed their objections. Further, it appears that the respondents herein were represented by their counsel before the learned executing court. And that being the position, there was no requirement for issuance of notice to the aforesaid respondents.
Lordship, petitioners, lordship. The notice was issued to us.
Notice was issued to
Us, decree holders. In place of respondent, it may be recorded as decree holders. There is 1A, B, C, they all are decree holders.
no,
47 petition is filed by them.
no. The designation of the parties
Yes.
in this petition is reflected in our order.
Office, put this petition notes. DH oblique office. This is decree holders. If it is recorded decree holders, lordship, it will cover everything. But learned court has recorded as defendant.
There is no requirement for issuance of notice. The proceed respond and to the petitioners, present petitioners. The matter has already been delayed by several years. In that view of the matter, this court is of the view that the impugned order dated 20th-9/2024 fails to withstand the legal scrutiny, and therefore the same stands set aside and quashed. It is provided that the learned executing court shall proceed to hear and dispose of the petition. No, petition number
Mixed case number 130 of 2024. Sir.
Dispose of the Mizzi case number 138 of 2024 in title execution case number 55 of 2023. In accordance with law, in terms of above this
As time limit, we can be
Mizzi case number 130. Above the CRPIO number 431 of 2024 stands disposal at this motion stage itself.
possible time limit will be given for disposal of this petition within 1 or 2 months. Possible.
The
Only hearing is
learned counsel for the petitioner, however, submits that a direction may be issued to the learned trial court to execute to dispose of the title execution case within a period of 2 months.
Not on title execution case. Now, first he has to dispose of this section 47 petition. That petition may be disposed of within 1 month, Lordship, or 2 months.
No, to dispose of the title, no, to dispose of the
Next case number
petition
138.
file under section 47, read it 151 CPC within a period of 2 months from today. I find substance in the submission of Mr. Urques, the learned counsel for the petitioner. Accordingly, it is provided that the learned executing court shall make an endeavor to dispose of the petition under section 47, read it 151 CPC within a period of 2 months from the date of receipt of certified copy of this order.
Much obliged.
Item number 8,
Yeah, please, Your Lordship. Lordship, this application is directed against the impending order dated 19/8/2024, passed by the Barnet Civil Justice Union Division number 2, Guwahati, whereby the court below partly allowed the issues tried to be raised by way of amendment in the plain by the respondent number 1, Your Lordship. Now, the brief facts is there. The respondent number 1, being the plaintiff, filed a suit before the learned court below, Your Lordship, wherein the respondent number 1 was the owner of the suit land. And in the suit land, Your Lordship, on the southern part of the suit land, there exists a G+1 old RCC building, Your Lordship. And in the year 2013, the respondent number 1 gives the entire land to the respondent number 2 builder for construction of multi-story building, but in the agreement have not mentioned about the existence of the G+ old building, Your Lordships. And after completion of the building, Your Lordships.
There is one caveat.
Yes.
Sir.
Take down. Caveat or they heard caveat instance. This is.
I have submitted, I file objection. The marriage fixed in the month of December. But I will file objection in the meantime and dispose of. Because the petitioner had already filed an application for amendment of WS. And 9 pages of amended portion has allowed already. Both the petition, amendment for plain filed by the respondent and amendment for WS filed by the present petitioner defendant. First allowed the pair of the amendment of the WS by filed by the present petitioner. And I have no objection. But subsequently I filed that not considered my pair. That's why I approached before the Honorable Court, and Honorable Court directed the learned trial court that dispose of the matter as early as possible. And accordingly dispose of by partly allowed the pair of amendment. And against that order, the present petitioner defendant preferred this instant revision petition. Because there is no injustice. They illegally, the building terrace part, rooftop, has illegally constructed and thereby sold out to the present petitioner. I challenge that part parallelly, which was, I have come to know, illegally sold out after filing of the suit. The subsequent event and the barely approach before the Honorable Trial Court. That was allowed. Against that order, the present petitioner defendant preferred this
Lordship,
instant petition.
I did
I file objection and no stay order may be granted, and that may be disposed of as early as possible. That is my submission.
Okay, then let him file objection.
okay, in the meantime, sir, Lordship, the operation of the impending order.
At
may be
December
stayed.
December something. I will file in a short time. I will file
Operation of
objection.
the impending order may be stayed, Your Lordship.
No required. This December it is fixed. I will file at least 1 or 2 weeks.
December.
After 2 weeks, I will file objection. Matter may be fixed.
Okay. Heard, Mr. Your good name, please.
A. Chaudhary.
A.
Chaudhary.
A. Chaudhary, learned counsel for the petitioner. And Mr.
Okay, bro.
A.K. Borda, learned counsel for the respondent. In this petition under Article 227, read with Article 115 of the Code of Civil Procedure, 227 of the Constitution of India. Read Section 115 of the Code of Civil Procedure, the petitioner. Petitioners have put to challenge the correctness or otherwise of the impugned order dated 19/8/2024, passed by the learned Civil Judge Junior Division, number 2, Kamrup M. Guwahati, 21, dated 25/1/2021. Upon which Ms. case number 33 of 2021 is registered. In title suit number 122 of 2019. It is to be noted here that by the impugned order dated so the learned trial court has allowed the petition filed by the respondent number 1 stroke plaintiff for amendment of the plaint under order 6 rule 17 read with section 151 of the Code of Civil Procedure. Mr. Bora, learned counsel for the respondent, submits that he may be granted some time to file objection and the matter may be finally disposed of. Accordingly, it is provided that recessal list the matter on second week of September, November,
On 13th November.
13 November.
Yes.
On that day, an endeavor will be made to finally hear and dispose of the petition.
In the meantime, Lordship, at least stay may be granted, Your
No,
Lordship, because Your Lordship,
December
order
12,
is
13,
bad, Your
is not
Lordship.
of the.
order is absolutely bad, because the issue
that
raised
is
by
the
the,
Central
ought to have
Honorable Court.
raised at the
Filing
time
of
of
the
filing of the
after
suit,
both the parties.
Okay, interim period, the petitioner will be considered on next date. If we fail to dispose of the petition on that day, we will consider your prayer on that day.
Item 36.
I praise your lordship.
Yes, on the other day, I have heard you.
Yes,
I am asking the law clerk to find out something. We will pass the order here. Our only concern is that the nature and character of the suit, if changed by
my lord,
this
the,
amendment.
if your lordship see my amendment petition, nature and character will not change.
Okay, in that event, we will consider the decision referred by you.
Items for admission, item number 9.
Okay. But we are against an order passed by the executing court. We had secured a decree which was affirmed by this honorable court. And later when we went for execution, the executing court held that the decree itself is a nullity and is not executable, which is why we are here, my lord. Lord, page 16, your lordship will find the plaint, my lord.
So I have seen one Okalatnama. Is it filed? This one. Are both the parties ready to hear?
Yes, my lord, I am ready.
Who filed this Okalatnama?
Yes, fine. I am from Supreme Court, my lord. I am appearing for the first time before my lord.
Yes, Mr. Decker.
Yes. My lord, so I'll just place the background in a nutshell, my lord. We as plaintiffs filed the suit saying that we are owners of a plot of land covered by DAG number 240, my lord. We say that out of the total land, we had sold off certain parcels of land and we retained 1 kotha 16 lechas. Now 1 kotha 16 lechas is the suit land given in the suit.
we say that the defendants were occupying land on the contiguous Dag on the east, which is covered by Dag number 238. So 238 is theirs, 240 is mine. Now, my allegation was that they came and encroached the land in Dag number 240, 1 kotha 16 lechas, and therefore we sought recovery of possession. Now, in the written statement, Manoj, they took up a plea that after having sold the land, and a portion of the land of Dag number 240 was also acquired by the PWD. So after the transfers and the acquisition, there was hardly any land left, and therefore we were not entitled to either a declaration or a recovery of possession. So they basically say that we've exhausted our area in the Dag since we've sold it, and the remaining portion was acquired by PWD. Now, during the course of the trial, Manoj, the trial court ordered a commission to see as to who's possessing how much of land. That commission report I've annexed as Annexure 5 at page 50. I'll just place what was there. So the commission said that besides Dag number 238, of which they are the recorded pattadars, they're also occupying additional land of 1 kotha 4 lechas in my Dag number 240. So the commission report was in my favor, and after perusing all the evidence on record, the trial court held that they at best could have retained only Dag number 238, and their possession over 240 is illegal, and therefore I'm entitled to recovery of possession. I'll just quickly place the findings of the trial court, Manoj, page 44, if your lordship takes it.
Yes.
The last portion, Manoj, the last paragraph. The land of Dag number 238 and 240 have been surveyed by the Commissioner ASO and submitted the report in sketch map. The Commission has stated in his report that the defendants are in possession of 1 bigha 1 kotha 6 lechas of their land in Dag number 238, Patta number 9. And in addition to that, the defendants have been found in occupation of land measuring 1 kotha 4 lechas of the Dag number 240. The defendants are found in possession in total of land measuring 1 bigha 3 kotha 8 lechas. The land of Dag number 240, which is under occupation of the defendant, has been shown in red color in the map as Kho, measuring 1 kotha 4 lechas. In view of the above discussion of evidence on record and facts and circumstances appeared in the suit, I have arrived at the decision that the defendants have been occupying the plaintiff's land. Neither party filed objection against the report of the commissioner, and hence the report is taken into consideration. The defendant did not apply for cross-examination of the commissioner. The plaintiffs have prayed for declaration of right title and interest and eviction of the defendants from the suit land measuring 1 kotha 16 lechas, but the land which is found in occupation under occupation of the defendant is measuring 1 kotha 4 lechas only. The defendants have no right, title and interest on the above mentioned land, 1 kotha 4 lechas of Dag number 240. In the cross-examination, the DW1 has not claimed land under Dag number 240 of Patta number 5. The defendants have failed to prove that the suit land is a part of Dag number 238 of Patta number 9. The issue number 5 is decided in affirmative in respect of 1 kotha 4 lechas covered by Dag number 240 and of the Patta number 5, and the issue number 9 is decided negatively against the defendants. Now 6 and 10 are the reliefs. In view of the discussions in issue number 5 and 9, the defendants are liable to be evicted from the land measuring 1 kotha 4 lechas of the suit land covered by Dag number 240, Patta number 5 of village Gaurpandu. The defendants have been possessing now, claiming the suit land as part of the Dag number 238. It has been discussed above about the suit land and found that the same is not the part of the defendant's Dag 238. The defendants have no claim on the land in Dag number 240. The defendants are not entitled to a decree for confirmation of possession on the 1 kotha 4 lechas of the suit land. The issue number 6 is decided affirmatively in favor of the plaintiff. The issue number 10 is decided against the defendant. So at the foot of that page, my lord finds the order. In the result, the suit is decreed with cause of the suit, and the counterclaim is dismissed on contest, declaring that the plaintiffs have right, title, and interest on the suit land measuring 1 kotha 4 lechas covered by Dag number 240 of Patta number 5, and the defendants are liable to be evicted theresoon. So it transpired during trial that their claim is limited to 238, which is to the east of 240. And they were found in possession of excess land covered by 240. And therefore, though we had claimed 1 kotha 16 lechas, the trial court held that I'm entitled to recovery only in respect of 1 kotha 4 lechas, which was found to be in their illegal possession. Now, my lord, against this, my lord, they approached this honorable court in an RFA 24 of 2009. That judgment is at page 57. Oh, Lord, just to indicate the grounds of appeal taken by the respondent in the appeal, my lord, will kindly turn to page 65.
Yes.
Para 13, my lord. The learned counsel for the appellant submitted that it was the pleaded case of the respondents in the plain that the total area of land in DAG number 214 was 3 kotha 16 lechas. There was no statement to link the said land with the suit land described in the schedule of the plain, which was covered by DAG number 240 of KP Patta number 5. In contrast, as per the commissioner's report, the land in DAG number 240 of KP Patta number 5 was 4 kotha 16 lechas. And out of the said land, 2 kotha 7 lechas was used by PWD. According to the respondents, land measuring 1 kotha 6 lechas was sold by registered deed and land measuring 14 lechas was sold by unregistered deed. However, as per the commissioner's report, the purchasers had purchased 1 kotha 5 lechas from the pattadar and were occupying it. Therefore, on the basis of the case projected in the plain by the respondent, the commissioner's report did not match, and as such, the commissioner's report could not have been the basis of the decree in the suit. It is submitted that the commissioner was appointed to fish out evidence for the respondent in support of his contention. The learned counsel for the appellant has placed reliance on so and so, so and so. Per contra, learned senior counsel for the respondent has submitted from the pleadings that it is apparent that the mentioning of DAG 214 in para 3 of the plaint was erroneous, because elsewhere in the plain, including the statements made in para 2 as well as the schedule of the plain, the land is described as DAG number 240. In this connection, by relying on the case of so-and-so, the learned senior counsel for the respondent has submitted that no prejudice was caused to the appellant because of wrong mentioning of the land covered by DAG number 214 in one place of the plain, while in the rest of the plain, the land was stated to be covered by DAG number 240. Now, my lord will kindly see page 67, my lord. Paragraph 8, points of determination were formulated, and para 18 deals with point of determination A, that is regarding the commission's report. Point of determination A is taken up first. At the outset, it is seen that in this appeal, the appellant has challenged the impugned judgment amongst others on the ground E, that the learned trial court had misread and misconstrued the report submitted by the commissioner after survey of the suit land, and as such, the impugned judgment and decree is liable to be set aside. Thus, the appellant has neither challenged the order of appointment of the commissioner passed under Order 26 Rule 9, nor the manner in which he had made the investigation under challenge. It does not appear from the record that any attempt has been made by the appellant during trial to examine the commissioner. The order sheet dated so-and-so of the learned trial court reflects that the commissioner, that is the assistant settlement officer, had submitted his report, and the next date of the suit was fixed on 2/8/2007 for filing of objection by the defendant. On 2/8/2007, as per the order sheet, it is recorded that the learned counsel for the defendants had not filed written objection, and it was verbally submitted that the next date should be fixed for hearing, and it should be mentioned that the defendant had raised objection against the report of the ASO in respect of the demarcation of the suit. Hence, it was ordered that the said report would be considered at the time of hearing of the argument of the suit and delivery of the judgment. In view of the discussion above, the ratio laid down in case of so-and-so is not applicable under distinguishable facts of the present case in hand, because in the said case, the order for appointing an advocate commissioner for field inquiry of the suit property was challenged by way of revision. Under the circumstances, in the absence of any challenge to the appointment of the commissioner or his report in the considered opinion of this court as per the provisions of Order 26 Rule 10-2 CPC, the report of the commissioner and the evidence taken by him was allowed to become evidence in the suit. Thus, in the absence of testing the veracity of the evidence by the appellant by cross-examining the said ASO, the said evidence can be relied upon by the learned court, just like all other evidence tendered in the suit. Moreover, the ratio laid down in the case of Praga Tools Corporation Limited is not applicable in this case. In the said case, the Honorable Supreme Court had directed the trial court to record findings. As such, it was held that though the trial court may have appointed the commissioner to carry out survey, but ultimately the finding had to be recorded by the court. In the present case also, the learned trial court had appointed a survey commission, but the findings was recorded by the learned trial court. It is seen that Musammad Safina Khatun, PW1 had deposed to the effect that the suit land pertains to Patta number 5, Dag number 240, belongs to Musammad Gulijan, mother of the plaintiffs. She did not state about the measurement of the boundaries of the suit land or about the measurements of the land sold. However, in the cross-examination, the PW1 gave the measurement of the suit land by stating that the total land of Patta number 5 was 4 kotha 6 lechas, out of which 2 kotha 12 lechas, out of which the case for 2 kotha 12 lechas, and that had also stated about that the measurement of the land sold was 4 lechas without registration and 2 kothas was sold by registered salary. It is also seen that while in his cross-examination, the DW1 had categorically stated that they were not claiming any land of Dag number 240. He had denied that the garage and the house was on the land bearing Dag number 240, but stated that the garage was on the land bearing Patta number 16, Dag number 238. And he had also stated that now 1 kotha 2 lecha remained in Dag number 238. He had further stated that a counterclaim had been filed in respect of the land bearing number 238. It is seen that in the cross-examination, DW 2, 3, and 4 had described the 4 boundaries of the suit. Thus, by virtue of the statement made in the cross-examination, the appellants through their DW had established the case of the respondent. My lord is about to rise.
Will resume after 5 minutes?
Very good. Complaint.
Yes.
Lord, we were at page 69.
Yes.
Para 20. Coming to the report submitted by the commissioner, who is the ASO, it has been mentioned in the said report that as per record, Dag number 240 of KP Patta number 5 contained 4 kotha 16 letters. The names of the pattadas were so-and-so, 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 7 in total. No? It was stated that there was 1 bigha, 1 kotha, 8 lechas in Dag number 238 of KP Patta number 16. The names of the co-pattadas are so-and-so, so-and-so, so-and-so. It was reported that on spot verification, it was seen that Safiq Ali, Moinul Ali, and Atawar Hussain had constructed house on 1 kotha 4 lechas of land of Dag number 240. Thus, the finding recorded in the commissioner's report, the appellant was found in occupation of land measuring 1 kotha 4 lechas in Dag number 240 of KP Patta number 15, over which the appellant admittedly had no claim. Therefore, a dispute of such nature can only be resolved by carrying out a local inspection of the suit land by the land revenue staff. Therefore, the ASO, being one of the concerned land revenue officer, was not only competent to carry out the local inspection of the suit land, but his report as a commissioner appointed by the court, having not been challenged by cross-examining him, cannot be discarded. Thus, when the learned trial court had based its decision on the basis of the pleadings and evidence on record, this court is unable to accept that the decision on the relevant issues are based on commissioner's report alone. It is reiterated that no ground has been taken to challenge the veracity or correctness of the commissioner's report or on the manner in which the inspection was carried out. So this was regarding the commission's report. So if I may just reiterate, their grounds of objection in the appeal was that number 1, you had said the total land to be 3 kotha 16 lechas, whereas the commissioner says 4 kotha 16 lechas. Secondly, it was urged that the commissioner's report is also incorrect, and therefore the trial court should not have decided the issue based on the commissioner's report. This honorable court negated both these grounds and held that as per record it is 4 kotha 16 lechas, Secondly, the commissioner was validly appointed. You did not take any ground of challenge insofar as the commissioner is concerned. You neither cross-examined him under 26 Rule 10, and therefore we will accept the commissioner's report. These were the clear findings of this honorable court in the RFA. Now, based on these findings, other grounds, I will not trouble your lordship with that concerning non-joinder and maintainability. Eventually, at page 74, their appeal was dismissed.
Yes.
Now, for the judgment attained finality, I reckon there was no challenge for the challenge before the Supreme Court. This judgment had attained finality. Now, thereafter, my lord, the matter went for execution. Now, when it went for execution, at page 78, your lordship will find nearly a 30-page long application was filed under section 47, contending that the decree is not executable and it is obtained by fraud. Now, just to indicate, page 81, if your lordship takes up, the same ground which was urged in the appeal, that you have yourself said that 3 kotha 16 lechas is a total land, so you must deduct the sold portion and the acquired portion for 16 lechas, 3 kotha 16 lechas was taken. Now, para 1.7, however, due to arithmetical clerical mistakes and errors arising from accidental slip and or due to fraudulent depositions on the part of the decree debtors, the trial court in its final order and judgment at page recorded, it appears that after deducting the sold and acquired land from 4 kotha 16 lechas, they say correct figure as per plaint is 3 kotha 16 lechas as per plaint of the plaintiff. The land remained in the suit dag and patta comes to 1 kotha 2 lechas. Note, had the court taken the correct total land as 3 kotha 16 lechas, as mentioned in the plaint, correct figure in the decree will only be 2 lechas. So whatever that they had been urging before the first appellate court, that this honorable court, that there has been the total land should have been taken as 3 kotha 16 lechas and not 4 kotha 16 lechas, was re-urged. Now, page 84, 2.3 again is the same reiteration that it should be 3 kotha 16 lechas, and thereafter several judgments and ratios were relied on. It was alleged that there was a suppression of material fact because we did not disclose the exact area acquired by the PWD. And it was therefore prayed that the execution be stalled. Now, against this, we filed a written objection, but I will straight away come to the executing court's order at page 111, my lord. This is also a very long order, my lord. It goes on to quote Greek philosophers and eventually hold that the judgment passed by this honorable court and the trial court was also fraudulent. Page 118, your lordship will find the points that were formulated by the executing court. As your lordship found, 111 is the starting and
Yes.
page 118 onwards, if I may read. From this is the second paragraph. From the aforesaid disputed facts between the parties, I deem it fit and proper to frame following points for determination to decide the case in hand. Number one, whether the judgment and decree dated 18/9/2007 passed in title suit number so-and-so is obtained by playing fraud upon the court. Two, whether the judgment and decree dated 18/9/2007 passed in title suit number 324 of 2003 is non-executable. Now let us take the first point for determination. Whether the judgment and decree dated so-and-so passed in title suit number so-and-so is obtained by the plaintiff by playing fraud upon the court. As the subject matter of the case is fraud, it reminds me of famous quotes of Greek writer come tragedian, namely Sophocles, and I would like to state for the purpose of enlightenment of all in order to work in a right
Mr. Decker, forget about that.
My lord.
You come to the reasoning given by the trial court.
Now,
No, by the court.
121 again, my lord.
121.
120. No, my lord, we'll see from page 120 itself. That portion of the judgment was quoted, and page 120 onwards. From the aforesaid para of the impugned judgment passed by my predecessor, learned civil judge, senior division, what transpires is that the then learned civil judge had totally relied upon the survey commission report to arrive at his finding to the effect that the excess land measuring 1 kotha 4 lechas found in the possession of the defendants belongs to the plaintiffs. So let us take the aforesaid survey commission report to find out as to what does it contain which compelled my learned predecessor to rely upon that report. The contents of the report runs as the survey and inspection of land of Dag number 240 reveals that as per official record, the land of Dag number 240 covered by Patta number 5 contains total of 4 kotha 16 lechas, out of which 2 kotha 7 lechas is utilized as PWD road, as shown in the trace map in yellow color. 1 kotha 4 lechas is in possession of defendant, as shown in trace map in orange color, and remaining 1 kotha 5 lecha is in possession of the purchasers. The report also states that during the survey of Dag number 238 of the Patta number 16, the defendants, in addition to their land measuring 1 kotha 18 lechas, 1 bigha 1 kotha 8 lechas, are enjoying excess land measuring 1 kotha 4 lechas of the plaintiff and excess land measuring 16 lechas of the government. Now, from the aforesaid survey report, what is noticeable is that the report do not specify the name and the numbers of the purchasers who are occupying 1 kotha 5 lechas land only in the suit land, which is very vital in my considered opinion, as because if we peruse the Jamabandi copy relied upon by the plaintiff as well as by the learned predecessor, we will find that the plaintiffs in the year 1985 had sold their land measuring 2 kotha to different sets of persons. That is, the land measuring 1 kotha 6 lechas sold to some Banwarlal Jain, and 14 lechas sold to Champak Lal Khate and Nabok Khate from the Dag 240. Now, if that be so, then the report of the survey commissioner becomes clouded with suspicion, because both the report of the survey commissioner and the certified copies of the Jamabandi relate to the same date, that is 1/8/2007. And if we believe the survey commission report wherein it is stated that it was prepared on the basis of the revenue record, then the land of the purchaser cannot be 1 kotha 5 lechas as stated in the survey report. Rather, it should be 2 kothas. That apart, if we peruse the record, particularly order dated 26/7/2007, the suspicion over survey report become more stronger, because the aforesaid order reveals that the survey commissioner was given writ only to inspect and take measurement of Dag number 240 belonging to the plaintiffs and not to conduct survey on Dag number 238 belonging to the defendants. The conduct of the survey commission raises serious question as to what prompted the survey commission to deviate from the direction by the court and take measurements of the land in Dag number 238 belonging to the defendants when there is a specific prohibition from the court. But interestingly, there is no explanation in this regard in the evidence of the plaintiff. Further, if we again peruse the commissioner's report meticulously, what we will find is that it also speaks about the possession of excess land measuring 16 lechas belonging to government by the defendant, but interestingly, it is again silent as to which Dag the government land relates and towards which side it is situated. The trace map appended with the survey commission's report speaks three more Dags besides the land disputed, Dag number 240, and all these Dags are shown adjacent to the land of the defendants, and those Dags are Dag number 229, 237 and 241, but nowhere in the trace map there is any mention about the above government Dags. So the report of the commissioner under the circumstances appears to be ambiguous and vague. Further, it also does not speak about the procedure as to how the inspection and survey was done, nor the survey report was supported by field book, which is mandated to look into when the commissioner is not examined upon the court, more particularly to about the procedure method applying by him to arrive at his finding. But unfortunately, case record reveals that the field book was withheld and my learned predecessor got misled by the survey commission report. I'm pausing here, my lord. The trial court is trying an application under section 47, my lord. Now it has gone to the merits of the case. It has fished out the survey report. It is trying to find fault in the manner in the commission was carried out. All of this have already been tested in the appeal. And this honorable court categorically held You did not cross-examine the commissioner, so you are debarred from raising all these issues in an appeal. And the executing court entertains the very same grounds in an application under section 47. But if this is not going behind the decree, what would be, my lord? This is precisely what has been reiterated time and again, that the executing court is supposed to execute the decree as it is. It cannot go behind the decree. Now it has gone on to reappreciate evidence. It has gone on to check records. It has found fault with the manner the commission was carried out. I've already referred to the findings of this honorable court, where the court held that it is a proper commission done. Now it is as if the executing court is taking up a fresh appeal of sorts. Now, my lord, after all this, my lord, finally, it concludes about the PWD, my lord, at page 124. It now examines pleadings, whether the pleadings were in order or not in terms of Order 7, Rule 3. Now, let me know that it is a settled position that one who comes to equity must come with clean hands. And it is also a mandate of law as laid down in Order 7, Rule 3, that where subject matter of the suit is immovable property, the plaintiff shall contain a description of the property sufficient to identify. In other words, it is a bounden duty of the plaintiffs to give proper description of their land so as to facilitate the court in determining the disputed rights, claims of the parties over the disputed properties. But surprisingly, the plaintiff has made claim of land measuring 1 quota 16 lechas in his plaint without proper description and without detailing the exact measurements of the land acquired by the PWD. Rather, they had suppressed the material fact of acquisition of land measuring 2 quota 7 lechas by PWD by making statement to the effect that a small part of the land from their dag was acquired by the PWD for widening the road. The conduct of the plaintiff from the aforesaid averment does not appear to be fair. In accordance with law, the land acquired for PWD from plaintiff's land was acquired through the land acquisition case and after giving compensation for acquisition. But the plaintiff, despite being well aware of the fact and despite having knowledge about the quantum of the land acquired by PWD, preferred not to divulge about the exact quantum of land in his pleadings. The conduct of the plaintiff suppressing the material facts as to proper description of the land and quantum of the land compelled this court to take an adverse inference that they with an intention to deceive and mislead the court, since the institution of the suit had suppressed the exact quantum of land acquired by PWD, but fortunately later on it has come to light that it is not a very small amount of the land as averred in the plaint. Rather, almost half of the land from dag number 240 was acquired by the PWD. That the false statement of the plaintiff, coupled with their conduct, withholding and suppressing the fact relating to quantum of land acquired by PWD, points towards only one conclusion, that the plaintiff did the same with ulterior motive, which is nothing but to obtain judgment and decree by playing fraud upon the court. More so when it is found that the report of the survey commissioner given was against the entry made in the revenue record of right and against the writ of the court, and which further fortifies the aforesaid fact that a fraud was committed upon the court in obtaining the judgment and decree dated 18/9/2007 in TS so-and-so. Accordingly, this issue is decided in the affirmative and in favor of the judgment debtor. Now, my lord, I'm not actually required to answer this, but let me explain the position here, my lord. The executing court says that 4 quota 16 lechas or 3 quota 16 lechas, whatever be the total area, from there we have to deduct the land sold to the purchasers and then deduct the land acquired by the PWD. Now, perhaps the executing court wants to indicate that since I did not disclose the exact quantum of land that was acquired by the PWD, and now it has come to light that it was 2 quota 7 lechas or so, if we deduct the land purchased and the land acquired, then the land retained would be just 2 lechas. Now, what the trial court has fallen in error is this. The trial court has not gone into the question whether PWD had acquired the land that was retained by me after the sale, or had it also acquired land that was already sold. Now, I have at page 131 onward, I have shown the land acquisition notifications. And page 131, your lordship will find Hauri Mal Jain and at page 132, Sampath Mal Khate. So these two are the persons to whom I have sold land. So the acquisition happened not just from the land retained by me, but also the land of the purchasers. So that arithmetical calculation that we must first deduct the land sold to the purchasers and then again deduct the entire land acquired by the PWD is also erroneous. And that is an exercise that the executing code ought not to have, or perhaps cannot have taken, given the limited scope of section 47. Now, I would say, my lord, the order on the face of it is without jurisdiction. It is beyond, it is in excess of jurisdiction, my lord. Because under section 47, the court is only required to decide questions regarding execution, discharge, and satisfaction of the decree. Now, there are several judgments, my lord. I'll just place one judgment recently passed by the Honorable Apex Court, my lord. 2023 SCC Online 139. SC Online 139. Now, the earlier authorities were discussed, which is why I'm placing this, this has summarized the position. Para 10 onwards.
You come to the ratio of this case?
No, look, para 10.
Directly?
Yes, para 10 onwards. A bare perusal of the aforesaid provision, that is section 47, shows that all questions between the parties can be decided by the executing court. But the important aspect to remember is that these questions are limited to the execution of the decree. The executing court can never go behind the decree. Under section 47, the executing court cannot examine the validity of the order of the court which had allowed the execution of the decree in 2013 unless the court's order is itself without jurisdiction. More importantly, this order dated so-and-so was never challenged by the pending judgment debtors before any forum. The multiple stages of civil suit invariably has to go through before it reaches finality is to ensure that any error in law is cured by the higher courts. The appellate, the second appellate, and the revisional court do not have the same powers as the powers of the executing court, which are extremely limited. This was explained by this court in so-and-so versus so-and-so. The exercise of powers under section 47 of the court is microscopic and lies in a very narrow inspection hole. Thus, it is plain that executing court can allow objection under 47 of the court to the executability of the decree if it is found that the same is void ab initio and a nullity apart from the ground that the decree is not capable of execution under the law, either because the same was passed in ignorance of such a provision of law or the law was promulgated, making a decree inexecutable after its passing. The court further noted the validity or otherwise of a decree may be challenged by filing a properly constituted suit or taking any other remedy available under law on the ground that the original defendant absented himself from the proceeding in the suit after appearance as he had no longer any interest in the subject matter of dispute or did not purposely take interest in the proceeding or colluded with the adversary or any other ground permissible under law. The reality is that civil matters take a long time to be decided and regretfully does not end with a decision, as execution of a decree is an entirely new phase in the long life of a civil litigation. The inordinate delay which is universally caused throughout India in the execution of the decree has been a cause of concern with this court for several years. In Rahul S. Shah versus so-and-so, this court had observed that a remedy which is provided for preventing injustice in the CPC is in fact being misused to cause injustice by preventing timely implementation of orders and execution of decree. Then it had observed as under the execution proceeding, which are supposed to be a handmaid of justice and subserves the cause of justice, are in effect becoming tools which are being easily misused to obstruct justice. So, my lord, given the scope of 47, my lord, this was not permissible at the first stage, the first place, my lord. Secondly, my lord, these grounds which I just read out, my lord, which the executing court had pondered upon as to whether the commission was entitled to measure to DAG number 238, whether there has been arithmetic calculation. These grounds have already been decided in the appeal. Now, to re-urge them in in an execution proceeding is to give a new lease of life, as the Supreme Court calls it. Now, all said and done, Manoj, they may find fault on various aspects, Manoj, but the case of the defendant is confined to DAG number 238 only. Because, and that is something the court had repeatedly taken note of, this honorable court, that so long as your claim is confined only to DAG number 238, how are you concerned with what is happening in DAG number 240? Thirdly, Manoj, that finding of observation of the ASO and the finding of the learned trial court and also of this court, that you have entered into possession of 1 kotha 4 lechas in DAG number 240. That is a factual determination that you cannot re-agitate in the execution proceeding again. So that is a clear finding, which unless set aside by a higher court, the executing court must presume or proceed on the assumption that they are occupying 1 kotha 4 lechas of DAG number 240. Fourthly, my lord, the commission report, again, going round and round, ultimately the executing court went into the validity of the commission report. So that bar for not examining him, which this honorable court had opined, that you cannot question the commission report unless you've made an examination under 10, Rule 10, was again negated by the executing court because he precisely did that, went into the validity, correctness, and the procedure adopted by the commissioner's report. And lastly, my lord, like I've already said, the acquisition may have happened from the sold portion and the retained portion. Now, to come to a finding that it must have happened only from the retained portion and therefore I'm left with only 2 lechas is something which is beyond the materials on record and is therefore perverse. So that is all, I'll reply.
Yes, my lord. The question is, only legal question before this court is whether the executing court can refuse a decree which is found to be a nullity. Challenging a decree or judgment, validity is something different.
No, the question is, can the executing court go behind the decree?
That is a normal rule, my lord, with respectful submissions. That is not absolute. Number of rulings of Supreme Court says that if it is found to be a nullity, even it is confirmed by Supreme Court, any judgment,
No,
the
can
subordinate court can say no.
No, the question is, can the court, while dealing with the application under section 47, can decide such issues?
Yes, that is my question, that is my humble submissions, that any stage a nullity judgment decree can be challenged, objection can be taken, and it can be taken in execution stage, and execution court can refuse it. Number of rulings, my lord, may can pass on, and before that I can also show that what is the fraudulent, not only in trial court, not only appellate court, not only before the execution court, also before this CRP. I have prepared a small chart showing in what manner. Second, what has been suppressed before the High Court? The docket order, daily Roznama, it is called Roznama, you call here, daily orders of the trial court, where something very important, the trial court has given restraint order to the survey report and he acted according to that mandate of that matter. That is also important. My lord may see this chart, my lord, so that how fraud has been committed, and thereafter we see that how the law helps the executing court to say no to a decree obtained by fraud and how it is a fraud. My lord, I'm just passing. Argument or concept. My lord, what is this small one-page chart, my lord? There are 3-4 tables that I have made it. That what is the total length at various stages, at 9-10 different stages, and then what is the land sold, then what is the land acquired, then what is the remainder, and then what is the page and reference number from where my lord can know that this is a fact that I am stating, how the court have been cheated. Number one, as per plaintiff, what they say, this is a page 17 of the this revision petition. What they say, what is the total length? This says total length is 3 kattha 16 lesa para 3. Then the land sold, they say, they admit that 2 kattha is sold. Then in para 3, they say that very small part of it is acquired by the land. It is not specific, very negligible. Accordingly, they claim 1 kattha 16 lecha is the remainder. My lord, they filed an amendment application before the trial court. By order dated, and that was refused, my lord. And the amendment application, this revision petition also, at page 8, para 11, they have admitted that but they were not allowed, my lord. 5th line. They said amendment was not allowed, my lord. And there is a specific order in the trial court which says this amendment is rejected, my lord. Order dated 9/6/2004, and application was made, and this application was rejected by order 9/8/2004 of the trial court. My lord. Now then see depositions, what the deposition PW1 says. PW says, I have 4 kattha 16 lecha. Goes beyond the pleadings, number 1. Then they admit, I have not only sold 2 kattha, I have sold 2 kattha 4 lecha. 4 lecha by way of unregistered documents. 2 kattha by way of registered documents. Then they say land acquired is 1 kattha 10 lecha. And remainder is 1 kattha 2 lecha. My lord, may kindly see page 44 of this revision petition where the trial court says that she has sold 2 kattha 4 lecha. My lord, got it? Second paragraph, PW has stated in its cross-examination, my lord, got it?
Yes.
That they sold land 2 kattha by way of registered deed and 4 kattha by way of unregistered sale deed. Now, by this way, this land sold is 2 kattha 4 lecha. It is decided. Now they cannot revert back. I have sold less or more. Then they say in cross-examination that kattha acquired by the PWD is 1 kattha 10 lecha. Further, they say that acquired by land 5 kattha. From the evidence deposed by PWD in cross-examination, it appears that land measuring 1 kattha 10 lecha was acquired by the road, and it appears that after deducting the land, acquired land from 4 kattha 16 lecha from the plaintiff, land remained in the suit dark. Patta comes 1 kattha 2 lecha. So I am coming, how they are remainder they are calculating first. Then as per the survey report is at page 50, which is very controversial. Now survey report what says, according to this paper that I have seen, 4 kattha 16 lecha. They say the land sold is 1 kattha 5 lecha.
But I have not challenged that report.
I am coming one by one. I am coming one by one because in High Court, before the High Court, High Court has been misled by the counsel of the petitioner.
How?
that I'm coming. Let me explain it. My lord will conclude it. I don't want to jump to that conclusion. Let this court to reach to that conclusion that is how it is a fraudulent decree. Now, as per SO, they say 1 kattha 5 lecha is the land sold. When the plaintiff is saying on oath before the court that 2 kattha 4 lecha I have sold it. And Jamabandi is also showing that they have sold 2 kattha. Survey report is saying that I have sold, that petitioner have sold 1 kattha 5 lecha. Then disclosing the correct figure what is acquired by the PWD is 2 kattha 7 lecha. And remainder is 1 kattha 4 lecha. Now, the relevant part I am reading, page 50, as per the available records, the total land of the Dark 240 of periodical Patta number 5 of Moja Jaruk Bari is 4 kattha 16 lecha. Out of the aforesaid land, an area of land measuring 2 kattha 7 lecha in dark number shown part K in the trace map is being used by the PWD. 2 kattha 7 lecha, a very big land. The other part of the land measuring 1 kattha 4 lecha is shown in this matter is being possessed by the opposite party by constructing house, and remaining 1 kattha 5 lecha as shown in G part is being possessed by their purchasers, purchased by the same from the Pattadhar. They are saying that 1 kattha 5 lecha I have sold, the petitioner have sold. The petitioner admits before the trial court 2 kattha 4 lecha has been sold. Now, next very important line. On the other hand, apart from the possessing 1 bigha, 1 kattha, itna, the village, opposite party is possessing 1 kattha 4 lecha of the land of this number, 16 lecha of government, totaling an area of this much. Now, question is whether I've given this daily orders to the court, my lord. My lord, just kindly see daily orders I have given. I just I give you. Daily orders diye na usko. Daily orders I have given. You have got it. Yes, please. My lord, may kindly see order dated 26/7/2007.
Yes.
My lord, 26. It is said, put up today along with the application, praying the order directing ASO Guwahati to stop the survey land beyond the schedule of the land. Beyond the survey in trial foot number 9. Petitioner has stated that the notice issued by the ASO on this day is without jurisdiction on perusal. If the copy of the aforesaid notice, which has been produced before me by the petitioner today, necessary order shall be passed on the next date. After hearing both the parties, in meanwhile, direct the ASO Guwahati not survey land beyond schedule of land. Fix this date hearing on the petition and necessary order. What this survey has done, survey has measured the land of this other party.
You have obtained this from where?
Yes. Pardon?
You had obtained these orders from where?
This trial court, these are the orders of the trial court docket orders. A trial suit runs, and from the very first day, last date order is there, daily order, which you call Roznama, I think. This is copies, translated copy of the trial court records.
Record.
Yes.
Okay, then we will call for the record. We will see. It may not be the correct position.
Right, my lord, may call for the records, no problem. This is necessary, my lord.
Because these orders are uploaded by the system officer.
Yes.
Who is not acquainted with the court proceedings.
Yes.
So exact position may not be reflected in these orders.
My lord, more for satisfaction, I agree.
Hmm.
My lord may call the court file, no problem. I have got it translated by the some appointed official.
Maybe,
the
but
party has given.
we have to
My lord may call it.
Or else, my lord, we can submit certified copies of the order sheet. my lord.
available with you.
Not readily, my lord, we can take out if
They-
records take time.
My lord may better call the records, my lord. That will be better, my lord.
Hmm.
Because we may be showing some more thing, so record will be here. That will be better for my lord to understand what is going on.
Only thing your lordship will fix a date, my lord. My
Yes, no
execution-
problem.
Oh, sorted. Suggested that then.
Yes.
Govind,
नवंबर में इतनी जल्दी रिपोर्ट आएगा? Can it be December? You can take it. December third week में ले लो.
Third week is vacation time, promotion.
ठीक, आप second week में ले लो.
Third of December.
हाँ? No, third में. आप देखो ये आप 13 को ले लो. 13 को.
Oh, that time we will go on a motion.
14 को ले लो.
From then on.
It's okay, it's okay. Any Tuesdays or
Then
Wednesdays.
can you take in January
Submission
then? After vacation, January ले लो.
Submission
But, January will be too late, no? Execution.
It will not be
we
too
will not
late
affirm
because
by the High
my lord will make the order for following the file. It may come, very good. It may not come, my lord. I am traveling from the Delhi. So January will be better. My lord, November is some preoccupied, my lord.
Therefore, December, my lord, at least.
No, the
December.
record will definitely come.
Well,
It is
third week I am
hardly.
Third week I am available December third week. But my lord, my brother says there will be a motion matters. So last week is the
Not in the last
vacation.
week, in the second week or third week of December.
On 9th December.
Third week, ठीक है.
Third week, okay.
Can it be
But
12?
Bada-
Let it be 12 then.
Not
hearing.
12, okay. 12 December.
12 December.
12 December. I
Okay.
agree.
So do we keep the matter as
Yes,
further?
heard, my lord. Your lordship is
Heard Mr. B.D. Decker, learned counsel for the petitioner, and Mr. Your good name, please.
I am Jeevan Prakash, my lord.
Jeevan Prakash, learned.
Okay.
Are you senior advocate?
I am AOR from Supreme Court.
You are from Supreme Court. Assisted by Mr.
And Madhav Prakash.
Learned counsel for the respondent.
And Madhav Prakash.
Heard in part. List the matter on
On
12
December.
12 December. In the meantime, Regis shall call for the record from the learned trial court.
Records of title suit 324 of 2003.
Yes, records of titles of number
324 of 2003.
324 of
Complete record.
Right.
Oblige.
Number 10.
Lordship, kindly matter may be passable for the timing, Lordship. I think
Timely.
next in-
I'm so worried. I will not be available on second of Lordship. I have medical urgency.
Hmm.
But otherwise I have received instruction, Lordship.
No, Mr. Sokia will appear then. Let his senior counsel come.
But otherwise, pension proposal sent to the director from the education.
Pension
I
proposal
just
will be
inquired
sent,
about it.
Lordship.
Physical copy yet to receive by the director. That will be up to this. No physical copy from the quality.
Where is Mr. Bhuya? Good now.
14 Lordship, kindly at 2.
Okay, Mr. Soikia will appear then.
Okay.
You can go. Mr. Soikia, you keep it with you right now.
Item number 11.
My lord, in this matter, draft affidavit has been sent for vetting, my lord.
Hmm.
2-3 days will be record, my lord. Finally, the matter may be listed on 5th of November, my lord.
Okay. Heard Miss
R. Begum.
learned counsel for the petitioner, and also heard Mr. S.R. Rava, learned standing counsel for BTC.
My lord.
Mr. Rava submits that affidavit has already been prepared and sent for vetting, and press for listing the matter on 5th of November. Fair allowed.
Obliged.
At number 12. At number 12. At 2 p.m.
Lordship, otherwise, Lordship, in this matter, Lordship, as per order dated 12/9/2024, I was supposed to get the records. Lordship, can this matter be taken up after 1 week, Lordship? I have already informed the petitioner that the records are not available right now. So, Lordship, after a week, Lordship, I will get the records.
After a week.
Yes, Lordship. I'll inform the
None appears for the petitioner on call. However, Mr. Your good name?
D. Upamanyu,
The Upamanya, learned counsel for the respondent number.
Higher Education Department, Standing
Education
Council, Higher
Department
Education Department.
present.
I am for a petitioner, my lord.
That's it.
The last revision records are for me.
So he informed you about the position.
My lord, on the last occasion.
No, did I inform you today about the position that I was not?
Yes, my lord, yes.
Okay. Your good name, please?
RM Decca.
Heard Mr. R.M. Decker, learned counsel for the petitioner, and Mr. So-and-so, learned counsel for the respondent. Learned counsel for the respondent submits that he may be granted 1 week time to
Produce the record.
enable him to produce the record. Here is accordingly allowed, list the matter on. So do we fix a date?
Date may kindly be fixed.
When?
On 19, my lord.
November
18 or 19?
18 November.
1/8.
Lordship, can it be on 19th, Lordship? That is a hearing day, Lordship, Tuesday, 19th of November.
Okay. Okay.
Highly obliged, Lordship.
Deeply obliged.
Item 13.
May I please, your Lordship. In this matter, virtual request is there. Please have some personal difficulty. Can it be at 2 years? Lordship?
Okay.
Highly obliged.
Item 14.
Please, Your Lordship, this is a statutory appeal under section 47 of the Guardian and Words Act, by which section 7 application was rejected, my lord. Your Lordship will admit the appeal and issue notice to the respondent. Yes, it is a statutory appeal, my lord.
Heard Ms. Asroy, learned counsel for the appellant. This appeal under section 47 of the Guardians and Wards Act 1890 is directed against the order dated 1/7/2024. Passed in FC Miss within bracket G number 05 of 2023. Passed by the learned principal judge, Family Court, Dhuri. It is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition filed by the appellant seeking custody of the minor son under section 7 of the aforesaid act. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugn order dated so and so. Admit, issue notice to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process with any week from today. Recess shall call for the record from the learned trial court. Leaves the matter after 4 weeks.
Much obliged.
Item 15.
This appeal has been filed by the insurance company on the ground that this was not a permanent job, but tribunal has considered 50% as a future prospect, and there is a allegation of contributing negligence of both the vehicle. These are the grounds we will deposit 50% of the award.
Court Mr. S.K. Goswami, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 22/7/2024. Passed by the learned member, Motor Accident Claim Tribunal number 3, Kamrup M. Guwahati, in MSC case number 400 of 2022. Peruse the memo of appeal and the grounds mentioned therein. Admit, let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Recess shall call for the record from the learned tribunal. Release the matter after 4 weeks.
Petition is there, but we will deposit 50%.
50%. Within 2 weeks from today?
4 weeks.
No.
Deposit 4 weeks.
No.
We have to obtain a certified copy, you have to communicate.
Certificate copy will be available today evening.
Then the Lordship, next 3 weeks.
Yes.
Okay.
Item 16.
Please, Lordship. Then appeal file for the enhancement of the awarded compensation of the embassy case number 1201-2016. Date of judgment 12/7/2024.
What is the ground for enhancement?
The interest is not given, Your Honor, from the filing of the claim petition.
Since when it was given?
The order dated 12/7/2024. Judgment order.
From the date of order.
No, from the filing of the claim petition. Means the interest is not given from the filing of the claim petition.
From which date it was given?
It is given from
From the date of filing of the evidence on affidavit. Let notice go at this stage. Heard, Mr. Your good name?
As sub.
As
Sub.
learned counsel for the petitioner, no appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 12/7/2024 passed by the learned member MSCT number 2, Kamrup Guwahati in MSC case number 1201 of 2016. For enhancement of the awarded amount, it is to be noted here that by the impugned judgment and award dated the learned tribunal has directed the respondent number 1 to pay a sum of rupees 13,91,100 rupees. Where is the memo of appeal and the grounds mentioned therein? Admit, let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered also with ADM. Okay, can have it from today. Rest shall call for the record from the learned tribunal. List the matter after 4 weeks. What is your name?
As sub.
Your name is not reflected in the cause list.
I am appealing on behalf of Mr. N.D. Bhuya.
ND Bhuya.
On behalf of the
Can you appear before the court without your color number?
I am appealing on behalf of my senior.
Where is your senior?
Another two.
Another court. Let him come at 2 p.m.
No.
2 p.m.
Item number 17.
This matter on behalf of the Higher Education Department, Lordship, may I pray for 2 weeks further time to file my affidavit? For filing of affidavit, Lordship. Lordship, we are yet to receive instruction, Lordship, in this matter.
So I am appearing for respondent number 4 and 5.
Respondent number 4 and 5.
We had already filed our affidavit.
Okay. Heard, Mr. Your good name?
Your Lordship, I'm appearing on behalf of my senior S. Count, J. Paulo.
Your name?
J. Paulo.
J?
Paulo. P-A-U-L.
Learned counsel for the petitioner, appearing on behalf of Mr. S. Khan, learned counsel for the petitioner. And also heard, Mr. Your good name?
UP Chaliha, Lordship.
UP Chaliha. UP Chaliha, learned counsel for the respondent number 4 and 5. And Mr. Upamanyu, learned counsel for the respondent number
1, 2, 3.
1, 2, 3. Mr. Upamanyu submits that he has not received the instruction and price for granting him 1 week time.
2 weeks, Lordship.
Lordship, if you could fix a date around November.
2 weeks time for filing affidavit in opposition. Pair is accordingly allowed. This is the matter on
2011.
2011, okay.
Item 18.
Lordship, hearing this matter, Lordship, I have received my instruction, Lordship. Lordship, 1 week time may be granted to file the affidavit, Lordship.
Madam, any objection? No objection. Heard Ms. P. Burman, learned counsel for the petitioner, and also heard Mr. Upamanyu, learned counsel for the respondent number
1, 2, and 3, Lordship.
1, 2, and 3, and Madam,
Five.
learned counsel for the respondent number 5. Mr. Upamanyu, learned counsel for the respondent number so submits that he has already received instruction, and he will be filing affidavit in opposition within a period of 1 week from today. And accordingly prays for granting him 1 week time. Here is accordingly allowed. Recessal is the matter after 1 week.
The date will fix, Lordship.
After 1 week, on 8th November. Item 37, item 37.
Having happened and does. He does think does. Did you?
For bail hearing, item 19.
Sir, does you have received the case ID?
Scan copy is there.
Scan copy. Solicited case.
Solicited, Lord.
Solicited under section
376, 511, and 8 of POXO Act.
that what it says the case is pending.
With appearance, Lordship. Next date is 12/11/2024. For appearance.
Well, let the council come then to look. Any other matters and
So hearing on the order, like, for hearing on the order for. Hearing on the report.
RSA. Okay. Continue.
Item 20 for hearing under order 41, rule to CPC.
Please, Your Worship. Before I should take your worship to the substantial question of law and that of the admissions made by the parties.
Mr. Sutter,
Yes, my lord.
that matter on the other day we have not.
Yes, my lord. But my lord, one thing, without calling for the record, my lord, will it be proper to hear the matter at the admission stage, my lord? That is the only thing.
No, this order was passed on that day after hearing both of you.
My lord.
On that day, you could have pointed out that the record is required.
I was pointing out but my learned friend was insisting that no, let the matter be fixed up instead of motion to the admission, and on that day it will be taken up. So I agreed to my lord.
Yes.
And moreover, I don't want to.
Agreed by both the parties.
Yes.
It was agreed by both the parties. In fact, at this stage, Lordship will decide whether there is any substantial question of law involved in the case or whether stay can be granted. That is the matter.
No,
If there is no
to
substantial
arrive
question of law.
to Mr. Sharma, to arrive at that finding, I have to go through the record.
Thank you.
No, if you have enclosed all the relevant documents along with this appeal, then there is no problem, I think.
All
You
the
see?
matters are not enclosed.
Only, my lord, actually, the relevant document for this appeal, its main question is one gifted. Question is one gifted. So in condition number 3 of the said gifted, that is the only relevant question in the case.
Condition number?
Condition number 3 of a gifted, my lord.
What was that condition?
That condition says that the donee in the said gifted cannot transfer the property to any other person except one Brajendra Hajarika and her sons and daughters. That was the condition. So the entire case moves around that condition only. If that condition binds the present respondents, in that case, the appeal would have been allowed. And if that
No,
condition
whether
is
he
held by
is,
section 10, as the
no, whether he is entitled to impose such a condition in the gift deed.
that is section 2. That is landed first appellate court as well as landed trial court come to conclusion that that condition is illegal condition. That condition is hit by section 10 of Transfer of Property Act. And both the courts come to this finding that that condition is hit by section 10 of Transfer of Property Act. And another provision is that that condition is only for the dowry. Her legal heirs are not affected by that condition. So this is the main question for the case. That is why they have also agreed that record may not be required at this stage, because that has to be.
No, I never agreed to that, that the record is not required. Simply your lordship on that date on his insistence that the matter instead of coming into the stage of motion, that it be taken at the stage of admission, I agreed.
No.
That does not mean that I have wiped out all my claim.
Appeal always come at motion, admission stage, not motion stage. Appeal always come. That was also lighted also it was admission stage. So, but it was decided that it can be heard, both the parties can be heard and matter can be disposed of, whether there is any substantive question.
Mr. Sattar,
Yes, my lord.
if that is the question, I think without record we can decide the matter. Because you have already enclosed this certified copies of most of the documents along with this appeal.
The two documents, documents I have annexed, but only
Along with the
two-
gift deed?
Gift deed is also there, madam.
Yes.
Yes.
Then can we not
Gift
decide
deed
the
in
issue?
original is not there, but the copy of
Yes.
that is
Execution of gift deed is admitted. That is not.
Gift deed is admitted, yes. And the learned first appellate court also admits about that condition. But my lord, I want to show before your lordship the perversity where the learned trial court as well as the first appellate court have committed.
What is the decision of the trial court?
Trial court same. Trial court has also restrained respondent number 1 in case of using this, schedule E, my lord, and the first appellate court also restrains them. But so far the respondent number 1 is concerned, she has already alienated the property to the respondent number 2. So that observation becomes redundant because the person who is no more on record or holding the property, my lord, how that can be restrained? She has already alienated the property in favor of respondent number 2, whereas the learned trial court as well as the first appellate court speaks of restraining the respondent number 1. Who has already alienated the property and has left that place.
I am not disputing to that. That is another thing. What has happened? There are two issues. One issue they have raised in the case, the appeal is that the sale deed executed by the respondent number 1 in favor of respondent 2 is illegal because it is hit by this clause number 3 of the agreement. That is number 1. And number 2, there is that one strip of land is left for going to and fro by using as a path by all the parties concerned. So we have admitted in trial court as well as appellate court that we are not going to disturb that path. We are not going to disturb that path. So that we still are there. Path is required by us also, they can use also path. So that is not a question, that is not a question of dispute. Question of dispute is only whether the sale deed executed by the defendant respondent 1 in favor of respondent 2 in view of this condition number 3 is valid or not. Regarding injunction, yes, we say that we are bound by the order of injunction. We are not going to disturb that path. We also need that path. One path is there inside of inside of our land, and that is used by them also. We have not disturbed it. So trial court has said that yes, they have admitted that they will not disturb the path. Accordingly, trial court passed order that the path should not be disturbed. Injunction is granted as paid for the item. Of course, injunction will be granted upon respondent number 1 and 2 both. I have no objection.
Respondent number 1 is no more in position of the
Respondent number 2
property.
also against me also respondent injunction will be granted. I have no objection. That is another thing. So now only core issue is that whether my sale deed is valid or whether it's invariant in view of clause number 3 of gifted. That is only law point. Only law point is involved in this case.
My
Law
lord,
point, that is, so question is that whether that law point is substantial question of law, because that is whether substantial become a substantial question of law, the court will examine whether the trial court and first appellate court had come to the finding rightly. If the trial court and first appellate court has come to the finding correctly, it needs no need to drag the matter for 10 years. Once appeal is admitted, it will.
who is saying that the matter
So
will
that
be
is-
dragged for 10 years?
Yes,
When your lordship is sitting over the matter.
that is why I say that lordship has rightly fixed the matter for hearing on admission stage, it can be disposed of. That is why. That is why the lordship
No,
has rightly fixed.
no, that's all right. Now you tell me, can we hear the matter without the record or not?
Of course, my lord.
My lord,
Of course, my lord.
so far my knowledge goes, and
Mm,
so far my experience goes,
mm.
my lord, no second appeal is heard.
No, Mr. That may not be the correct position. I have seen some orders of this court.
Earlier, my lord, it was getting binded by the, book bindings were there. Bindings were there, my lord. But at the admission stage, no second appeal as of date has been disposed. to the
No,
best
yes,
of
yes,
my-
dispose of. That may not be correct position.
My lord, then I am subject to correction.
Mm.
Appeal can always be
Subject to
dismissed
correction.
if the court finds that there is no substantial question of law. If the court finds that there is no substantial question of law, the appeal will be dismissed.
Mm.
That is the position. So if court finds that there is no substantial question of law, court will dismiss the appeal. It's not required to give call for the, still if they read the record without admitting the case, the court may call for the appeal. It record it is here in the trial court, Guwahati itself. The matter may be kept for every
No,
admission.
the problem is that usually without admitting the second appeal,
That is,
records are not
that
called
is,
for.
that is why, and that is why I say that at this
Then
stage,
let us admit the appeal.
no, let us see, once the appeal is admitted, hearing will, your lordship knows that it will go to hearing list. So let us see whether there is any substantial question of law involved in the appeal that can, at this stage, court can examine this question. If there is no substantial question of law involved in the appeal, if the trial court and as well
No,
appeal.
that's all right. I am ready to hear the matter, but Mr. Sattar, his view is that a record is required.
Therefore, for deciding whether it involves substantial question of law or not, for deciding that matter, record is not required. And even if there needs some further records, I can submit all the documents before this court, certified copy, photocopy, in protested form, I can submit one copy to them. One copy
Yes,
to them.
Mr. Sattar.
My
I
lord,
can
my
supply-
lord,
They are also reviewing the document, but still I'm ready to supply all the documents in certified copy, protested from to the honorable court as well as to them also.
so
Yes.
what is the harm if the case is admitted?
No, harm, there is great harm.
And in the meanwhile, in the meantime, he submits the record before your lordship.
My lord, that is the entire relief. If the appeal is admitted, once the appeal is admitted, they got all the relief. Appeal
I'm
is
not
admitted.
asking for any
No,
stay.
let the matter be decided
not
whether
asking for any
no,
stay.
whether there is substantial question of law. If there is some substantial question of law.
Yeah,
if
substantial
this
question of
honorable-
law can be perused from page number 23, my
No,
lord.
they have
It
framed
can-
it. That is, they had framed it. Now the court will see whether it is substantial or not.
Yes,
That
I
has to
will
be
show you
seen.
that, no?
That is to be seen. Simply admitting, we don't know in any question of law they have framed that we do not know. Court will see whether there is substantial question of law involved. Because the Honorable Supreme Court already clarified in 2022 of Air Online that substantial question of law is different from question of law. There may be some questions of law, but whether it is substantial or not, that has to the court will decide. Let's wait a second. They will insist.
Okay,
that-
let us fix a date, then you produce all the relevant
Yes.
documents.
Yes, I shall produce all the documents in
Yes,
protested.
yes.
Then we will hear on the point of substantial question of law,
Yes,
my
if
lord.
there exists or not.
Yes, my lord.
All the documents to the satisfaction of the honorable court as well as to the satisfaction of the petitioner before your lordship.
Okay.
Yes.
Heard Mr. S. Sattar, learned counsel for the appellant, and Mr. Sharma, learned counsel for the respondent. On
On 13th November,
13 November. In the meantime, Mr. Sharma, learned
Is it-
counsel for the respondent
অলপ
shall
দেখি, দোকান
further
থেকে
receive
Yes, it will do.
20-22 মান
পিছত লাগে।
অলপ দেখি
before this court all the relevant documents pertaining to record of trial court as well as first appellate court.
22nd. Upgraded matter. Item number 30 for personal appearance, hearing matter.
Let me give 2 weeks time now.
We have already passed similar order in another petition. So we are dismissing the petition. This is not maintainable.
2 weeks time maybe.
No, no, no. No time. Next item.
Number 10. Number 10.
May I give the lordship? My lord, petitioner before your lordship is a retired, my lord, LP school teacher. He was supposed to be retired in the year 2018, but inadvertently he was retained in service up to 2021. Thereafter, my lord, he was released from service on verbal instruction. But his pension was not released. Now, my lord, they are whispering, my lord, for recovery. But no specific order is yet passed. Therefore, petitioner before your lordship. Lordship, kindly overlook this. I have.
Yes, Mr. Sokia,
My lord.
what is the instruction you have received?
My lord, education department, they have produced the instruction, my lord.
Yes.
They have sent it on 25th October 2024. A proposal has been submitted to the director of the pension. Today I confirmed from the director, my lord, but a physical copy yet to be received from the education department. This is the instruction from the education department.
Regarding, my lord, overstay.
Regarding, my lord, overstay or recovery, my lord, that part, my lord, that director of pension issue a specific order, my lord. After that, it can be considered.
So when you are going to file a affidavit in opposition?
My lord, in this matter, my lord. Let me obtain instruction about this letter, my lord, after that.
Later, my lord, this is, my lord, unnecessary, my time will be consumed because they will file, my lord, and director will say, my lord, the recovery is necessary. My lord, service, my lord, the book is necessary in this case, my lord. Because they have done mistake, my lord, in the service book, my lord, it is written, my lord, my retirement is in the year, my lord, 2025. Therefore, my lord, this petitioner before your lordship is innocent, my lord.
With whom the service book is now?
My lord, my learned friend may produce, my lord.
I cannot produce, but the education department can produce.
And there, my lord, in their
Retained by
affidavit,
the concerned inspector. my lord.
in their affidavit also it is admitted, my lord. It is page 38, my lord, that as per service book, my lord. Page 38, my lord, in the earlier round of litigation, my lord, they submitted one affidavit. There, my lord, they admitted that, my lord, as per service book, my retirement date would be, my lord, 1/1/1965, my lord. And there is, my lord, as per my instruction, my lord, there is no overwriting, nothing, my lord. It is, my lord, perhaps, my lord, then, my lord, BO, Block Elementary Education Officer, done this mistake, my lord. And that now, my lord, for the sake of, my lord, argument, my lord, they are taking this or that plea. Obviously, they will take, my lord. Because otherwise, my lord, they are apprehending that, my lord, they will be liable. But it is, my lord, this petitioner is, my lord, innocent, man. And that apart, my lord, when he joined in service, my lord, in the year 1993, my lord, then, my lord, service period was, my lord, 58 years. Without his knowledge, my lord, then it was made 59 years, then it was 61. Lord, obviously, my lord, he is a rural metric pass man, old man, my lord, he will presume, my lord, perhaps his service is extended again, therefore, my lord, he was not released, my lord. And when, my lord, he was verbally released, he immediately, my lord, left the office, my lord.
No, let them file affidavit then.
Service book, my lord, may be necessary, my lord, with all respect, because, my lord, service book
Okay,
will
okay,
reflect.
we will direct them.
Yes, my lord.
Heard Mr. M. Borbuya, learned counsel for the petitioner, and Mr. T. Soikia, learned counsel for the respondent number.
And
Soikia, you are for
pension
respondent.
department member. Respondent number 4.
Respondent number 4.
Right.
And Escort appeared for
For the
respondent.
education department member. She is appearing for 1, 2, 3, 5 and 6. 6 and 7.
Miss Escort, learned counsel for the respondent number. Learned standing
1, 2,
counsel for the
3.
respondent number 1, 2, 3,
5, 6 and 7.
5, 6, and 7. Ms. Kaur submits that she has received instruction and she will be filing affidavit in opposition shortly, and price for granting her some time. Here is accordingly allowed. List the matter on
18 November.
18. Mr. Borbuya, learned counsel for the petitioner, submits that in order to adjudicate the issue raised in this present petition, perusal of the service book of the petitioner is necessary, and therefore Mr. Borbuya submits that the standing counsel for the respondent number 1, 3, 5, 6, and 7 may be directed to produce the service book of the petitioner before this court on next day. Here is accordingly allowed. It is provided that the learned standing counsel for the respondent number so and so shall produce the service book before this court on that day, on next date.
Number 13 by VC Mode. Deep Domain.
May Lordship, please.
Yes.
Lordship, this is a regular first appeal. We have filed against a judgment and decree of learned civil judge senior division Tinsukia. So in the regular first appeal, necessarily Lordship indulgence that notice may be issued and the record may be called for. We have filed also an IA under Order 39, Rule 1 and 2 for consideration of an ad interim injunction. It's a landlord-tenant case. In fact, for 3 days, continuously the plaintiff was examined, cross-examined. And thereafter, for non-information, he could not appear, and the entire evidence was closed by an order dated 18/11/2023, including the other witnesses also. In fact, 5 witnesses were filed. The plaintiff number 1 was cross-examined 3 days, 2 days before the court and 1 day before the commissioner. And subsequently, for non-appearance, the entire evidence was closed, including the evidence of plaintiff number evidence 2 to 5. And this is the issue before this one. It's a matter of remand, perhaps. Yes, ma'am.
Heard Mr. B. Dutta, learned senior counsel assisted by Mr. J. Das, learned counsel for the appellant. This appeal under section 96, read with section 105 of the Code of Civil Procedure is directed against the judgment and decree dated 25/6/2024 and 2/7/2024 respectively, passed by the learned civil judge senior division Tinsukia. It is to be noted here that by the impugned judgment and decree dated so the learned civil judge senior division Tinsukia has dismissed the title suit number 11 of 2018 filed by the present appellant. Whereas the memo of appeal and the grounds mentioned therein, let notice be issued on the admit. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Press shall call for the record from the learned trial court. Leaves the matter after 4 weeks. Mr. Dutta,
My lord.
the respondent number 2 is advocate.
Yes, that is the whole issue, my lord, and therefore we filed an injunction order. What happened, my lord? Just the roof of my premises, the Dunduma town, he has obtained a permission fraudulently to construct his office over the roof. There was no staircase. What he did, taking the advantage that the defendant number one's daughter, he is junior, he constructed a staircase from our premises to reach to his office. When we objected, then we have filed suit, and a widow has fighted against Lordship is a mighty advocate. And the suit was unfortunately dismissed for default of, in fact, the inaction of the advocate of the plaintiffs, my lord. We have filed this appellant has also filed a complaint before the Bar Council against her advocates because of non-action on his part. And Lordship is very unfortunate that there may be a possibilities of collusion. So finally, a widow has lost her case. Absolutely is a clear case of defaulter. Now, Lordship, we have apprehend that taking the advantage of dismissal of the suit, they may the change of the character and the status of the premises. Therefore, a status quo order humbly prayed before this honorable court, my lord.
Let a notice go at this is this.
Yes,
Next step, consider your pair.
Lordship kindly considered that every day is, or Lordship is kindly appreciate that it is a fight, old widow, and the other side, Lordship may kindly appreciate.
Mr. Dotto, we are not concerned with who is widow, who is advocate.
Yes, correct, my lord.
So, let
just indicating, my lord.
If there is if any urgency arises, then you can mention the matter before this court.
So the urgency is, my lord, only the entire premises in their occupation, and they may change the character of the status quo, because otherwise the entire suit will be frustrated.
No, in such event, you can mention the matter before this court.
It is up to, I leave it to the honorable court. My only humble prayer.
Returnable in 4 weeks. Interim pair of the petitioner will be considered on next date.
Lordship, grateful, my lord.
Item number 16, timing matter.
Mr. Bhuya.
Yes, my lord.
Your junior appeared before this court, but his name is not reflected in the cause list and also in the Wakalatnama. Kobe, when the next date is fixed?
Appeal for enhancement, my lord. 4 weeks.
4 weeks. So we have already admitted the appeal and fix it after 4 weeks.
Timing item 37.
May it please also. On the last when the matter was hard on so praise for my name may be placed before the agency for the consideration. My commission appointment. My lord.
So on the other day, you have referred to decision.
Or I mean, I can show my decision also in my hand, my lord. In the case of WC 7291 to 2022 and SC Supreme Court case, my lord, 2027 Supreme Court cases 617.
Okay. Supreme Court কথা কৈ আছে Supreme Court court. Mr. Soikia,
My lord.
have you received this judgments from him?
My lord, NC Santos.
Yes,
NC Santos.
yes.
That judgment I have received. That is in 2020. Judgment I cited in Development Tiwari, that is 2022. my lord. In this regard, my lord, state has also issued a notification by saying that my lord, no more compassionate appointment be allowed. And Development Tiwari, my lord, that is, there are 7.5 very clear, my lord. That event lapses. Otherwise, my lord, that person died in 2006, my lord. Scheme said, my lord, immediately support to the person. If the concerned person is given.
That's all right, but at the relevant time, he was minor. He cannot apply.
My lord.
And in earlier round of litigation, this court has held that the rule is not inflexible.
That's, my lord, otherwise that's correct, but purpose of the scheme, my lord, that is very clear, my lord. Because, my lord, one children, my lord, his the entire family is not dependent upon him at that point of time. He is the dependent with his mother, my lord. If it is a case, my lord, that's mother claim, my lord, that is separate aspect, my lord. Then, my lord, Santosh.
So that's all right, but now what is your submission on this point? On this judgment referred by him?
My lord, this entire aspect that has already been discussed in the Devobhata Tiwari case, my lord, Supreme Court, my lord.
Pardon?
Devobhata Tiwari case, my lord, which was referred in earlier occasion, my lord. That is very much clear, my lord. When apart from the my lord judgments and all, my lord, first, that scheme, my lord, itself that said that immediately to support to the family, my lord. That is the scheme, my lord. And person concerned, he died in 2006. Now in 2024, my lord. Even, my lord, consideration of period is also required, my lord, because, my lord, 2006 he have to apply. Even otherwise, my lord, petitioner has no direct claim, my lord. His other person, his mother or other competent person is there, my lord. They have not taken this sums, or maybe they have taken this sums, my lord. We are not confirmed from that, my lord. This aspect, my lord, petitioner has no vested right otherwise, my lord. Because, my lord, 2006 and 2024, my lord.
No, that's all right,
Almost 18 years, my lord. Then scheme says that, my lord, that person, they are depend upon the concerned person, my lord, on the deceased employee, my lord. Employee died in 2006, my lord. Then this case, my lord, Devobhata Tiwari already said, my lord, they somehow they can, my lord, survive.
Where is that case? Devobhata Tiwari.
This one, my lord. There are 7.5 million.
No, how this judgment will help you?
Paragraph 7.5 million.
I have gone through it.
That has discussed about the lapses and all that.
No, there is no lapse on his part. At the relevant point of time, he was minor, and when he attained majority, immediately he applied for.
My lord, my submission will be that on that respect, my lord. Because, my lord, that point of time, my lord, he was the minor, my lord. And this definition of the family, my lord, which is specified in the 1983 notification, my lord, that is said that the first wife and other competent person. If he is able to show that there is no other competent person to apply under the scheme, my lord, then it will be a separate case, my lord, we can take into consideration. Because if no one is there, my lord. But in this petition, my lord, so other person is there, my lord. Probably they may avail it or they may not be avail it, my lord. And purpose of the scheme is also, my lord, very much clear.
If we are go by the judgment of this honorable court, my lord, Ashok Ranjan and Fazilan Nessa, they are also clearly stated that within 2 years, my lord, that has been complete, my lord. Because if somehow they manage to.
Thereafter, several round of litigations was going on between the parties.
No, my lord, some cases, my lord, court has decided, suppose, my lord, one person, he is 17 years, my lord. Suppose that point of time, or 16 years, my lord. He has left some month, 2-3 months, my lord, that the court has said, my lord, that can be, my lord, considered. If you are go to the, go by this office memorandum issued in 2015, my lord, it is also very clear, my lord, that within 1 year, every person, initially it was, my lord, 3 months, my lord. While passing the Ashok Ranjan, my lord. After that, my lord, Fazilan Nessa passed by this honorable court. Fazilan Nessa said, no, within 3 months it's not possible. Then it has extended to the 1 year, my lord.
When the notification was issued?
That earlier original notification 1983, my lord. Subsequently, my lord, that 1983, my lord, there is no specific time. In 2006, when Ashok Ranjan come, that is said make for 3 years, my lord. The government has issued notification. That notification put it to challenge, my lord.
No, his case was of the year 2000.
My lord?
His case was of the year 2000.
My lord?
His case was of the year 2000.
That, no.
When he
Ashok
applied
Ranjan,
for?
my lord, 2006, my lord.
Six.
That point of time, my lord, there is no specific time for submitting application. Ashok Ranjan has a discussion, they have referred this state level committee, this district level committee for, my lord. Subsequently, that government has issued notification by saying that within 3 months from the date of the decision, you have to.
No, whether it is mentioned in that notification that it will retrospectively it will come into force.
No, my lord, 2000 all notification whatever issued, my lord, earlier notification suspended, my lord. Because, my lord, 1983 exists, my lord. Thereafter 2009 notification that has set aside in Fazilan Nessa in 2010, my lord.
Whether all those notifications are available with you?
My lord, I have to search, my lord, because it's all notification, my lord. But I can search it, my lord. Otherwise, no problem. I can take it from the department also, my lord. 2009 notification, my lord. And subsequently, my lord, 2009 notification, then 2015 notification issued, my lord. Now 15 is.
No, the fact is that at the relevant time when he had applied for, there was no time limit.
No, 2006, my lord, judgment said, if any other pending cases, they have to be decided within 1 set, my lord. Then department has taken endeavor, my lord, to dispose all these applications, my lord.
Maybe at that time, writ petitions were pending, filed by him. And there was a direction of this court that the rule is not inflexible rule.
No, rule is, my lord, not inflexible, my lord. One judgment said, my lord. Because, my lord, subsequently, the Debabrata Tiwari has, my lord, discussed everything, my lord. Subsequently, my lord, that has discussed it.
You do one thing, you produce those documents.
My lord.
Notification of the year 2000?
2009, my lord.
9. Heard Mr. Edas, learned counsel for the petitioner, and Mr.
Might be the title 23-1 6 million. The notification challenge, my lord, on the case.
It is available on the record. You have enclosed that notification here. And Mr. P. Sokia, learned counsel for the respondent number.
I am looking for the government.
Learned government advocate for the state respondent. List the matter for further hearing on 4th or 5th.
On 5th.
5th of November, so as to enable Mr. Sokia to produce before this court the notification of the year 2009.
2009.
Any number, notification number?
I cannot.
To produce before this court a notification issued by the government of Assam regarding completion and appointment.
Timing item 19, bail hearing matter.
May have please, Your Lordship. The second bail application, Your Lordship. A charge sheet has already been filed, Your Lordship. Annexure 4. So I will pay Your Lordship. I will appear before the learned trial court and the trial court, lower court will pass order according to law, Your Lordship. The arrest and bail application, Your Lordship.
The first application was rejected
Yes.
on which date?
Annexure 3, Your Lordship. 6/3/2024, Annexure 20, page 22, Your Lordship order. And thereafter, Annexure 4, charge sheet was submitted on 30/11/2024, Annexure 4.
13/1/2024.
30/11/2023.
So what is the ground for preparing this second application then?
Seven application,
This second application,
yes,
what is the ground?
seven application was at that time, Your Lordship, we are not in position of the charge sheet, Your Lordship.
Charge sheet was not submitted.
No, submission was submitted, but we are not aware of the charge sheet, Your Lordship. So I pray Your
But
Lordship,
the
I will
record
appear
was
before
called
the.
for at that point of time.
Yes, in the meantime, already has been filed, but we are not in the knowledge, Your Lordship. So I pray for Your Lordship. I will appear before the learned tribe, and the learned tribe will pass order according to law, Your Lordship.
Yes.
Lordship, I only wanted to state here, he is shown absconder in the charge sheet, Lordship. Moreover, next date is fixed on 12/11/2024 for appearance.
That's why, Your Lordship, I will appear. The learned trial court will pass.
Pardon, sir, your good name, please?
R. Majumdar.
R. Mazumdar, learned counsel for the applicant, and Mr. K. Das, learned counsel, learned additional PP for the state respondent. This application under section 482 of the BNSS 2023 is preferred by the applicant Amir Hussain Amir Hussain, who has been apprehending arrest in connection with Dhing PS case number 170 of 2023, under section 376 511 IPC, reduced section 8 of the POCSO Act. Whether notice was issued to the respondent?
Yes, Your Honor. On 12/2, I was directed to take fresh steps, and accordingly fresh step was taken, Your Lordship.
Whether notice was served?
Yes.
When?
But it is not written there. On 12/2/24, Your Lordship directed to take fresh step upon respondent number 2, which was already taken, Your Lordship.
No, mere taking of step is not sufficient. He has to produce service report before the court.
Service report, I am sorry, Your Lordship, I have not gone through the office note, Your Lordship. The step was taken back long on February, Your Lordship.
When you have taken a step,
12, in February 24, Your Lordship.
do you have any document?
I have no document, but I have noted in my file, is there, Your
There is no office note and also order for issuing notice.
Therefore, Your Lordship was also pleased to call for scan copy of the CD. And several dates it was listed, Your Lordship.
Not several dates, only 2 dates.
2 days, 29, 24. And on
At the time of hearing, it has
27th.
come to the notice of the court that notice to the respondent number 2 has not yet been issued. Accordingly, it is provided that notice be issued to the respondent number 2 returnable on February fixed date,
Also on 14th November,
short date.
on 8th November.
8. The learned counsel for the applicant shall take passive step upon respondent number 2
Your
to
Lordship.
the public prosecutor, Office of the Public Prosecutor, Guwahati High Court. And after causing service of notice upon the respondent number 2 through the officer answer jurisdictional PS, Mr. K.K. Das learned additional duty shall produce a report of service of notice upon respondent number 2. Less than 8.
No registry, Your Lordship.
No, not registry. Office of the PP. PP.
Item number 21 for hearing under order 41, rule to CPC.
Over here, respondent initially filed a suit against the appellant for right title in interest and for recovery of possession. In the plain, the DAG number and the patta number was mentioned as DAG number as 17 and patta number 141. So you will kindly see
Mr. Koleta, what is the difference between this earlier cost title and the present cost title?
No, not post title, it's a substantial question of law.
Yes.
As regards substantial question of law, Lordship has observed that substantial question was not there. Amended memo of appeal. Amended memo of appeal was filed.
So, like the first memo of appeal, here also you have mentioned the grounds.
No, my lord. Kindly come to the ground 1, my lord. Ground 1, my lord. Whether the finding of the learned court below is hard in law.
So that is ground or substantial question of law?
Substantial question of law, because whether he can travel beyond the pleading, my lord. Kindly see, my lord. In plain, my lord, they have sought recovery of possession in respect of a plot of land, my lord, bearing DAG number 17 and of patta number 141.
If it is the substantial question of law, why you have mentioned it as ground?
Lord, I have.
You see the earlier page number 3 of earlier memo of appeal and the present memo of appeal, page number 4.
That is why, Lordship, I have prayed on the earlier occasion, my lord, to amend my, my lord, the substantial question of law. And
No,
Lordship
you
has
have
allowed
not
my
prayed
lord.
for this, but the court has directed you.
Yes, sir.
Again, you have mentioned it as ground.
My lord, there's substantial question of law stroke, my lord. Ground stroke, a substantial question of law.
Which, according to you, is the uh, most important substantial question of law
Well,
among the substantial question of law you have suggested in the memo of appeal?
My lord, kindly see, my lord, number 2 also, my lord. The document, my lord, exhibit A was, my lord, it was admittedly executed in the 1/3/1970, my lord, which is a 30 years old, my lord, document. So, my lord, section 90 of Indian Evidence Act, my lord. So that was not considered, my lord. At Lane trial court, my lord, it was, my lord, observed that this document exhibit A is not admissible. And whether, however, Lane appellate court, it is observed, my lord, that it is admissible, but failed to, my lord, prove the signature as per provision of section, my lord, the 67 of Indian Evidence Act. So a 30 years old document, my lord, whether 67, 66, section 67 Indian Evidence Act, my lord, whether it is necessary. And in plain, my lord, they have stated that they have sought recovery of possession of a particular plot of land, my lord, for a separate DAG number. And we have filed our, my lord, written statement along with counterclaim, where it was DAG number, a separate DAG number. But decree was, my lord, granted to the plaintiff in respect of the DAG number and patta number against which we have filed our counterclaim, my lord, for confirmation of possession. Then Lordship will find at page 11, schedule.
Pardon me, sir. And Coletta, learned counsel for the appellant. This appeal under section 100, read with order 41, rule 1 of the Code of Civil Procedure is directed against the judgment dated 16/5/2024 and the decree dated 38/5/2024 passed by the learned civil judge Borpeta in title appeal number 47 of 2022. Full stop. It is to be noted here that by the impugned judgment and decree dated so and so, the learned civil judge Borpeta has dismissed the appeal and thereby affirmed the judgment dated 4/7/2022 and the decree dated 5/7/2022 passed by the learned Munship number 1 Borpeta in title suit number 84 of 2015. Here is the memo of appeal and the grounds mentioned therein. This second appeal is admitted on the following substantial question of law. Number 1, whether the finding of the learned trial court as well as the first appellate court or whether the learned first appellate court as well as the learned trial court erred in law in traveling beyond the pleadings as well as evidence on record. While the respondent herein has prayed for a decree in respect of Dag number 17 of the Khedas Patta number 141 of Place Moripur under Mauza Paka district Barpeta. Whereas the decree has been passed by the learned courts in respect of Dag number 17 KP number 155 of Place Moripur under Mauza Paka district Barpeta. Number 2, whether the learned trial court as well as first appellate court erred in law in by failing to adhere into the provision of section 90 of the Indian Evidence Act 1872 in considering the exhibit A, the Katsa cell date dated 03/03/1970 exhibited by the appellant, which is more than 30 years old document. The court will also consider framing of further substantial question of law if found necessary at the time of hearing after giving notice to both the parties. Issue notice to the respondents returnable in 4 weeks, shall be taken by registered post with AD and also by usual process within a week from today. Registrar shall also call for the records from the learned courts below, place the matter after 4 weeks. Interim pair will issue notice at this assess.
No, the execution proceeding has been started, my lord.
When?
My lord, it is, my lord, after filing of this.
What is the number?
My lord, the number I don't have, my lord, at this stage, because the person from the, my lord, revenue department came and, my lord, they put their, my lord, the red flag. Person from the revenue department, my lord, came and measured the land.
You saw the number before the court, we will consider it. Issue notice. Interim pair will be considered on next date.
Unless there is a, my lord, at this stage, till date, my lord, status quo, my lord, till date, my lord.
You saw the execution proceeding. At least tell the number. Then we will consider. And if there is any urgency, you can mention the matter, we will consider.
Number 22, matters for orders.
None appears for the appellant on call, rest is always a matter after 1 week. In the event of subsequent.
I am for respondent number 7 only.
Acha. How about Mr. Sutter, learned counsel for the respondent number 7 present? 7 or 9?
7. HK Sharma is for 9, my lord.
HK Sharma or HR Sharma?
My lord, here it is mentioned HK Sharma respondent number 9 and R Dekar respondent number 9. Then Mrs. N Agarwal respondent number 7. She is along with me.
In the event of subsequent non-appearance of the appellant, appropriate order shall follow.
23.
23 Vice Chairman.
Well, office note dated 24/10/24 says below. Notice could not be served upon the respondent below.
Why?
She was absent at that time.
Take fresh step then.
My lord, may I take steps through court, learned court below?
How?
Because advocate is there. Through advocate, it can be served, my lord.
We can permit you dusty mode.
Dusty mode to the
respondent itself.
Third, Mr. Sahu, learned counsel for the petitioner. Office note dated 24/10/2024 indicates that notice upon the sole respondent could not be served. The learned counsel for the petitioner shall take fresh step by registered post with ADN also by usual process within a week from today. Thusly is also permitted. Place the matter after 3 weeks.
Because a date being fixed, because
22nd November.
22nd, obliging.
Item 24.
May please, Your Lordship. These applicants are applicants in the IS Civil 1622/2024, Lordship. They are plaintiffs. Their suit was decreed. Suit was for right title, interest, and recovery of possession, Lordship. Thereafter, on being in first appeal filed by the respondent, the first appellate court reversed the same and Lordship, the decree was reversed. Lordship. Against that, this present regular second appeal was filed and it is admitted, Lordship. During pendency of the regular second appeal, the respondent, we received an information that they have started construction, Lordship. We approached the police station, Lordship, and FIR was filed. That is annexure 1 of the miscase. And thereafter, as police are not taking any steps, Lordship, we filed this injunction petition praying for maintaining status quo for the suit length, Lordship. At least the suit length will be protected. My learned friend has filed objection that there is no prima facie case, there is no irreparable loss and balance of convenience. On last occasion, I have Lordship, that is
No, on the other day, you have submitted that
the appellate court is
in
not duty
appellate
bound.
stage, appellate court is not bound to follow the golden
Lordship,
principle.
that is Rintu Lahan case, Lordship. Rintu Lahan case, Lordship. There are 15, Your Lordship. 15 and 16, Lordship. It says that appellate court not required to discuss the said principle as it is not exercising original jurisdiction, Lordship. And in one more decision, that is 2004 8 SCC 488, Lordship. In this case, what happened, Lordship, the trial court given status quo, Lordship. Para 4, Your Lordship will file. Or para 3, Lordship. The appellant had filed civil suit number 541 2004 8 SCC 488. The appellant had filed civil suit number 541 of 2000 for possession of the suit scheduled property with an application under Order 39, Rule 1 and 2, seeking injunction restraining the respondent herein from alienating the suit property and putting up any construction thereon. The trial court on the interim application filed by the appellant granted an order of temporary injunction as prayed for. The appeal filed by the respondent herein before the learned district judge came to be allowed, holding that alienation made, if any, will be subject to the law of lease pendants and construction. If any put by the respondent will have to be removed at his own risk and cost in the event of the suit being decreed. a revision filed against the said order to the High Court came to be dismissed by the impugned order, wherein the High Court recorded an oral undertaking given by the learned counsel, which is as follows. And counsel for the respondent on instruction from Rajinder Das, son of Baldev Das, on the other hand, has stated that the respondent has no intention of alienating any part of the property, and further that the defendant shall raise construction, if any, at his own risk cost without claiming any compensation. It is further stated that if the defendant inducts any tenant in any such premises so constructed, the person inducted would be made aware of the pendency of the litigation and would be bound by the judgment and decree passed in the suit. It is in view of the above statement made by the learned counsel for the respondent that the High Court, without considering the grounds raised in the revision petition, proceeded to dismiss the petition. Para 9, Lordship. While it is true that the lower appellate court did not go into the question of prima facie case and held that the appellant had not made out any such case, the High Court did not go into that question at all. Be that as it may, Mr. Zai is right in contending that unless and until a case of irreparable loss and damage is made out by a party to the suit, the court should not permit the nature of the property being changed, which also includes alienation or transfer of the property, which may lead to loss or damage being caused to the party who may ultimately succeed and may further lead to multiplicity of proceedings. In the instant case, no such case of irreparable loss is made out except contending that the legal proceedings are likely to take a long time. Therefore, the respondent should be permitted to put the scheduled property to better use. In this case, the respondents were allowed to construct, Lordship. On that regard, the Supreme Court says that we do not think in the facts and circumstances of this case, the lower appellate court and the high courts were justified in permitting the respondent to change the nature of the property by putting up construction, as also by permitting the alienation of the property, whatever may be the condition on which the same is done. In the event of the appellant's claim being found baseless ultimately, it is always open to the respondent to claim damages, or in an appropriate case, the court may itself award damages for the loss suffered, if any. In this regard, since the facts of this case do not make out any extraordinary ground for permitting the respondent to put up construction and alienate the same, we think both the courts below, namely the lower appellate court and the high court, erred in making the impugned orders. The said orders are set aside and the order of the trial court is restored. Lordship, the main submission of the appellant's friend is that the suit property may kindly be protected, Lordship. Status quo, if they are constructing and residing on that property.
Status quo is also a kind of injunction.
Yes, Lordship. For that only I am
Now
saying.
the thing is that without satisfying the three golden principles,
Lordship, my
can this
appeal
court
was
grant
admitted.
this
My lord,
My
status quo?
appeal was admitted, Lordship. This
No,
means that there is a
admission of
prima facie
appeal
case.
itself does not create any right in your
No,
favor
Lordship,
for
that
getting
means,
the
Lordship,
order.
there is a prima facie case. Until and unless there is a prima facie case, my appeal had not been admitted, Lordship. It
Yes,
is a-
Mr. Zain.
my lord, whatever my learned friend cited the decision, in that decision, trial court has injected the matter. Trial court has passed the injunction. And the appellate court cannot go into the prima facie also. But in the instant case, the injunction petition filed originally in this court. Not in this court is not for the injunction matter. This court is not standing as a appellate court. Whatever, Your Honor, in this case, my learned friend cited the decision of Guwahati High Court into Lahore. In this case, the trial court has passed the status quo order. Not directly, the High Court has passed the injunction order. So these two cases cited by my learned friend will not help the learned friend in this case. Because in this case, neither in the trial court nor in the appellate court, the learned friend, the appellant or the applicant has filed any injunction petition. So at this stage, this honorable court will consider that whether there is any golden principle of prima facie case or irreparable loss and injury or balance of convenience is there or not. Madam, one case.
No,
That I agree, Lordship. That-
Mr. Jain, while the second appeal is admitted for hearing, why we have undertaken construction?
I have not undertaken the construction. My plea is that whatever the houses and outhouses I have constructed, that is before the filing of the suit, not now.
Then
And they have not denied this.
Lordship, the maintaining status quo, how they
Why-
will be affected?
Why,
Lordship?
when the applicant cannot.
They will enjoy the property, they are in
Cannot
possession
prove
of
the
the
prima
property,
facie
Lordship.
case. Whether I have constructed by now or at present or the earlier filing the suit. My lord, in our case.
Then unless there is a prima facie case, Lordship, RSA would not have been admitted, Lordship.
Hmm?
My case has already been
No, no,
admitted, there is a
My lord,
substantial question of
the,
the formal.
our High Court, it says that the injunction is not a matter of charity.
And they, in all the objection paragraphs, already mentioned that the new construction, they have not taken, Lordship. Already there is a construction and they are residing over the property.
Hmm.
So let them reside, Lordship. The status quo, no further construction, no alienation may be made of the suit property. And because
When
there is
there must be some prima facie case. There must be some ground. Simply filing injunction petition is not sufficient. This honorable High Court.
No, Mr. Jain, can you assure this court that during the pendency of this RSA, no construction will be undertaken in the suit property?
It is about to indirect injunction. I can assure,
Hmm.
but indirectly.
No,
it is-
only we will record your submission here.
Yes, that I can do. That I can do.
Hmm.
But it amounts indirectly injunction, interim.
Not an injunction, not injunction. We are going to dispose of this IA on the basis of your assurance.
Then I have to take some instruction. From me, I assume this court.
No,
that, there
no.
will be no construction.
No
during
construction will be
pendency.
undertaken by. But you have no confidence upon your party.
And the,
My assurance can be.
categorically stated that they have not taken any
No,
new
my-
construction.
My assurance can be recorded.
All the paragraphs. That much is sufficient. Your lordship may record that no further construction will be taken by the
Hmm.
lordship. The lordship can dispose it up and fix a date for hearing, lordship, so that we can
Hmm.
dispose it, the entire regular second.
Heard Ms. R. Sodhane, learned counsel for the applicant, and Mr. Jain, learned counsel for the respondent. This interlocutory application is preferred under Order 39, Rule 1 and 2 of the Code of Civil Procedure for temporary injunction till disposal of the connected regular second appeal. Ms. Sodhane, learned counsel for the applicant, submits that the applicants have already preferred one second appeal, the regular second appeal before this court, and the same has already been admitted. And the matter is fixed for hearing on next date. Ms. Sodhane further submits that during the pendency of this RSA, the respondent here in this application have already have undertaken construction in the suit property. And if they are allowed to construct, they're allowed to continue with the construction, then the same will change the nature and character of the suit property. And thereby prejudice will be caused to the applicant, and therefore Ms. Sodhane contended that till disposal of the RSA, the parties may be directed to maintain status quo. On the other hand, Mr. Zain, learned counsel for the respondent, submits that no new construction is undertaken by the respondents in the suit property, and whatever was constructed that was prior to filing of the title suit before the learned trial court, and that he can assure that no further construction will be undertaken. No construction will be undertaken by the respondents in the suit property. But having heard the submission of learned advocates of both the parties, and also considering the submission, especially the assurance given by Mr. Zain, learned counsel for the respondent, that no construction will be undertaken on the suit property to change its nature and character during the pendency of the suit, this court is inclined to dispose of this application at this stage.
During the pendency of the regular second appeal.
Yes.
RSA.
is not listed today.
Lordship.
Only the IA is listed.
RSA already LCR received service also complete. So if your lordship fix a date for hearing in the month of December, lordship.
No, to pass an order, this RSA is not listed today. Only the IA is listed. So you can mention the matter later. on.
Obliged.
Item 25.
May you please, your lordship? There is an interlocutory application number 240824, which is a section 5 application for delay in filing of the connected FAO of 54 days. The honorable court had directed us to take steps, and accordingly we had taken steps as well. But the latest office note says that the steps could not be completed due to non-submission of forwarding form, which is missing. Maybe granted some time, we'll complete the steps.
Heard, Mr. Your good name?
G. Kaushik.
G. Kaushik, learned counsel for the applicant. What is the office note dated 24/10/2024? It is stated that the notices could not be communicated to the respondents. The learned counsel for the applicant submits that he may be allowed to take facilitative upon the respondent, where is accordingly allowed. List the matter after 4 weeks. After 4 weeks.
26.
May it please, madam. There is a delay of 19 days in preferring the present second appeal, madam. The opposite party number 1 has entered appearance by way of filing an caveat, madam. We've already served them a copy.
19 days.
19 days.
Any objection?
May I please, your lordship, I want to file my affidavit in opposition to this effect here, my lord. In the petition, it is written as 24 days, but I have recently been served the copy last week only, your lordship. And they have given the affidavit as on 25th of September. Now it's end of October. So, your lordship, I may be allowed to file just my affidavit in opposition to that effect, your lordship. Because I need to see the.
No, only 19 days.
It's given as 24 days.
Where?
Here, in the.
24 days, my lord, we had calculated, but the officials, they have said that, my lord, it is not 24 days, it is
19 days.
19 days. So we have corrected it accordingly.
Yes, your lordship, I need to just check that part important, your lordship. Kindly in 2 weeks' time, your lordship, I'll just file it.
Heard, Mr. Iqbal, learned counsel for the applicant. And Mr. Your good name, please?
S. Sancheti, my lord.
S.
S. Sancheti.
Learned counsel for the respondent.
Only for respondent number 1.
Respondent number 1. This application under Order 41 Rule 3A, read with Section 151 of the Code of Civil Procedure, read with Section 5 of the Limitation Act, is preferred by the applicant for condonation of delay of 19 days in filing the regular second appeal. The learned counsel for the respondent number 1 submits that he may be granted 2 weeks' time for filing objection in this application. Here is accordingly allowed. Recessal is the matter after 1 week.
My lord, like notice also go on other respondents.
Other respondents not served.
Not so, today it has come for the first time.
Let let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Mr. So-and-so learned counsel appears on behalf of respondent number 1 and receive notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Mr. So-and-so learned counsel for the respondent submits that he may be granted 2 weeks' time to file a written objection in this application. Pair is accordingly allowed. Place the matter after 4 weeks.
27.
Right, Your Lordship. Lordship, the IS 3266 has come up for delay of condemnation, Your Lordship, for 69 days, Your Lordship.
69 days.
Yes, Your Lordship.
Heard, Mr.
J. Kotoki, Your Lordship.
J. Kotoki, learned counsel for the applicant. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant. IFCO Tokyo General Insurance Company Limited for condonation of delay of 69 days in preparing connected appeal under Section 173 of the MB Act. Files the application and the documents enclosed therewith. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today.
28.
List after 4 weeks.
Delay petition first time, Lordship, so notice may only be issued, Lordship.
Same order, private. Okay, after 4 weeks.
29.
My lord, the limitation by 164 days, my lord. It is for the first time. Population.
After 4 weeks.
For hearing, item 31.
Yes, 31 and 32 are together, my lord. Begin, my lord, but perhaps I can begin, but perhaps time may not permit.
Time may not permit.
These two appeals are connected, my lord. I'll have to-
22 and 22 meter. So start today then. Mr. Sutter,
Yes, my lord.
if we could not be able to complete hearing, then we will keep it at parted.
Let it be kept as part of that.
Yes, you start.
My lord, 23, 11, 22, my lord. 5 substantial questions of law were formulated. My lord has RSA 170 for it.
170.
Yes. Now, my lord, it's a judgment of reversal, my lord. If I may take your lordship straight away to the appellate judgment. At page 82.
Yes.
Page 84, the facts would begin, you know. We were the plaintiffs, my lord. Our suit was initially decreed. Against that, they preferred the appeal, my lord. May I place from the facts, my lord? 84. The brief facts of the case is that the plaintiff herein, as respondent, Shri Abhishek Shah, had instituted the suit against the appellant defendant Radhashyam Sarkar for declaration of plaintiff's right, title, and interest and possession over the suit land, recovery of possession, and permanent injunction. For the purpose of convenience, the parties herein are referred to in the same status as they appeared in the suit. The plaintiff's case is that one Dondiram Kumar and Roheswar Kumar were the exclusive owner and possessor of a total land covered by Patta number 25. After disposal of land by various manner, a portion of land measuring 3 bigha 4 kotha 7.5 lachas remained in the hands of Sri Ananta Kumar, son of Dondiram Kumar, Sri Arun Kumar, and Sri Jagdish Kumar, both sons of Roheswar Kumar. Those three persons jointly executed a power of attorney appointing and empowering Ranjit Kumar De, son of Dasarath Kumar De, being deed number so-and-so, dated 16/10/1996, to sell the above referred 3 bigha 4 kotha 7.5 lachas. That Sri Ranjit De, on the strength of the aforesaid power of attorney, being deed number 5299, dated 16/10/1996, sold 1 kotha 5 lachas of land out of the aforesaid land to Ravi Paul by executing a registered deed of sale bearing deed number 3421/98, dated 23/6/1998. Said Ravi Paul, after 7 years, sold the said land to Subhash Chandra Das by registered deed of sale bearing 5835/07, dated 3/8/2004. So, Sri Subhash, that should have been 2004. Anyway, that's a typographical error. Para 7. Sri Subhash Chandra Das has sold out the suit land to the plaintiff by registered deed number 3152, dated 7/6/2006, through his power of attorney, Sri Suman Das Gupta. That at the time of execution of the sale deed by Ranjit De in favor of Ravi Paul, boundary of the land was shown wrongly, and as such, subsequently, by respective rectification deeds, all the subsequent purchasers, right from Ravi Paul, got their boundary of sale deeds rectified. That in the month of March 2008, when the plaintiff along with Srimati Motushi Dotto started construction of a boundary wall and was about to affix a gate on the southern side of the land, defendant appeared and started claiming the suit land to be his own and forcibly tried to enter upon there, but could not succeed. But finally, the defendant, in a most illegal and arbitrary manner, forcibly entered upon the suit land with the help of some hired ladies and took possession of the suit land. Defendant contested the suit by filing written statement, whereas he had denied all the claims of the plaintiff and further stated that predecessors in interest of defendant number 1, principal defendant Sunil Kaur and Boloram Kaur, purchased a plot of land measuring 2 kotha 10 lachas from Dondiram Das, son of Horendranath Das, and Muhammad Anwara Hussain Diwan, son of Sonalla Diwan, both are residents of Guwahati, by registered sale deed number 5373, dated 4/5/1984. The said Dondiram Das and Anwar Hussain purchased the land from Satyaram Kumar and Narayan Chandra Kumar, both sons of Dhoniram Kumar of Maligaon, Guwahati. Satyaram Kumar and Narayan Chandra Kumar purchased the land from one Nandiram Kumar, son of late Gangaram Kumar of Maligaon, by deed number so-and-so, dated 4/1/1951. The defendant number 1 purchased 2 kotha 10 lachas, which includes the suit land, from Sunil Kaur and Boloram Kaur, by deed number 298, dated 28/3/2005, after disposal of the proceeding under section 145/46 by order dated 29/11/2004, and took possession of the land and became the absolute owner. And since then, he has been possessing the same by constructing rooms thereon and started living there. Whereas the pro forma defendant number 2 and 3 have admitted the pleadings of the plaintiff in their written statement. The grounds taken in the appeal is that the learned trial court committed grave error of law as well as facts on and passed the impugned judgment and decree, which suffers from various legal infirmities, resulting in miscarriage of justice, and the same being illegal and unjust is neither tenable nor sustainable in the eye of law, and as such the same is liable to be set aside and quashed. That the learned trial court failed to frame vital issue on the basis of the pleadings, such as whether there is cause of action for the suit, and decided the suit without giving any reason on the point of cause of action. Learned trial court decided issue number 1, 2, 3, and 4 without applying judicial mind, without considering the documentary evidence on record, and without appreciating the existing law of the land and without appreciating the evidence on record, and also erroneously decided the issue. As such, the impugned judgment and decree dated 4/6/2016 is liable to be set aside and quashed. That the learned trial court failed to notice that Exhibit 3, 5, and 8 all rectified after a gap of 10 years by changing the boundaries of the by deed of rectification dated 18/7/2008. The Exhibit 2 power of attorney dated 16/10/1996 contained no boundary by which the plaintiffs claimed to have purchased the suit land measuring 1 kotha 5 lechas out of 16 bigha 4 kotha 5 lechas, which was sold to him by his predecessor. As such, a plaintiff is not entitled to get a decree of recovery of possession without identifying the land. Learned trial court committed serious error as Exhibit 2 power of attorney dated 16/10/1996 contained no boundary and there is no discussion on finding to that effect, and the said power of attorney was not rectified though all subsequent deeds were rectified. So without rectification of the power of attorney by which the plaintiff claiming title, subsequent rectification cannot confer title in newly inserted plot of land, and subsequent rectification of the title deeds are baseless and confer no right, title, and interest. That learned exhibit court below completely bypassed Exhibit D. The judgment and order passed the order dated 13/10/2003 passed by the executive magistrate in case number 221M 1997 declaring possession of in favor of the predecessor of the appellant. Against said judgment, a common revision was preferred before the Court of Session Judge. The learned court by order dated 21/11/2003 vacated the order of attachment dated 21/11/2003 and by judgment and order dated 29/11/2004 said revision of Ranjit Day and others was dismissed and possession of Sunil Kar, predecessor in interest of the appellant, affirmed. Hence, the impugned judgment and decree is liable to be set aside. Upon pleadings, the learned trial court had framed the following issue: whether the plaintiff's vendor had acquired title to the suit property, whether the plaintiff's vendor had delivered possession of the suit land to the plaintiff, whether the plaintiff has been dispossessed by the defendant, whether the plaintiff is entitled to the relief as claimed for. Heard the argument of the learned counsels for both the sides, perused the entire case record from the rival pleadings of both the parties, and after going through the case record, the points that needs to be determined are whether the discussions made in issue number 1, 2, 3, 4, and 4 are bad in law and therefore the interference of this court is required, whether there is any perversity in the judgment dated 4/6/2016 passed by learned Munsif number 1 Kamrup Metro Guwahati TS number so and so, whether the interference of this court is necessary against the judgment and decree passed in Title Suit 133 of 2009. Reasons and discussion. For determining the aforesaid 3 points, let me appreciate the evidence on record and have a discussion on the issues of the trial court. Discussion and decision on issue number 1, whether the plaintiff's vendor had acquired title to the suit property. In the case in hand, plaintiff Sri Abhishek Shah has claimed that he had purchased the suit land wide registered sale deed, the Exhibit 11, dated 17/11/2007, from Subhash Chandra Das through his power of attorney Suman Das Gupta. That his vendor Subhash Chandra Das had purchased the suit land from Ravi Paul via Exhibit 7, the sale deed dated 3/8/2004. The further said Ravi Paul had purchased the land via registered sale deed dated 23/6/1998 from Ananta Kumar, Arun Kumar, and Jagdish Kumar, the legal heirs of the original owner, through their power of attorney holder, Sri Ranjit Kumar Dey. The power of attorney as well as the sale deed are exhibited as Exhibits 2 and 3. Thus, according to the plaintiff, the source of his right, title, and interest has flowed to him as well as to his vendor from the legal heirs of the original owners on the basis of the power of attorney, the Exhibit 2 executed by the owners in favor of Sri Ranjit Kumar Dey. Now, on perusal of Exhibit 1, the Chitta, it reveals that the suit land is a part of the total land measuring 16 bigha 4 kotha 5 lechas covered by DAG number 67 of Patta number 25, which stood in the name of Dondiram Kumar and Roheshwar Kumar, the predecessor in interest of Ananta Kumar, Arun Kumar, and Jagdish Kumar. Exhibit 1 further reveals that Dondi Kumar and Roheshwar Kumar were sole pattadars in respect of the whole plot of land, and Ananta Kumar, Arun Kumar, and Jagdish Kumar had executed a power of attorney in respect of a part of the land measuring 3 bigha 4 kotha 7.5 lachal without mentioning the boundary of the land. Therefore, in absence of the four boundaries, it is not only difficult but also impossible to identify 1 kotha 5 lachal out of the total land measuring 3 bigha 4 kotha 7.5 lachal. Under such situation, the power of attorney holder had sold a plot of land measuring 1 kotha 5 lachal out of 3 bigha 4 kotha 7.5 lachal on 23/6/2008 to Ravi Paul by Exhibit 3 by way of a specific boundary in the following way. North 16 feet road, south Ajit Kumar Chandra Das, east others land, west Purkashma. Subsequently, after 6 years, Ravi Paul had sold the land to one Sri Subhash Chandra Das, wide Exhibit 7. Finally, Subhash Chandra Das sold the said land to the present plaintiff, wide Exhibit 11, through his power of attorney holder, Sri Suman Das Gupta. Further, it reveals that subsequently, by rectification deed, Exhibit 4, dated 18/7/2008, the boundary of sale deed number 3 was rectified. Then, by rectification deed, Exhibit 8, dated 18/7/2008, the boundary of the sale deed, the Exhibit 7 was rectified. Thereafter, by rectification deed, Exhibit 12, dated 18/7/2008, the boundary of the sale deed, Exhibit 11, that dated 17/12/2007, standing in the name of the present plaintiff, was rectified to the following effect. North, land of landlord, south 16 feet wide road, east land of other Dag, west land of Ajit Chandra Das. Careful perusal of the evidence reveals that the rectification deed, the Exhibit 4, was executed by Ranjit Dey, the power of attorney holder of the original owner, without being authorized by Ananta Kumar, Arun Kumar, and Jagdish Kumar to execute such rectification deeds. Hence, it is apparent that Exhibit 4 was executed by Ranjit Dey without any lawful authority. Since the rectification in respect of the first sale deed is not as per law, hence the subsequent rectification deed will not bear any legal value. It further reveals that the purchasers, including the plaintiff, after 10 years of the execution of the first sale deed, the Exhibit 3, have tried to portray an entirely different plot of land as the land purchased by them through the respective sale deeds by way of rectifying the boundaries in their respective sale deed. That being the position, the case put forth by the plaintiff is not found believable and probable to inspire confidence in this court. In this respect, the learned counsel for the appellant defendant has relied on the judgment of so-and-so, wherein it was held that in terms of Order 7, Rule 3 CPC, plaintiff has specified the four boundaries and numbers in a record of settlement or survey so that the property can be identified. In absence of boundary and area of the suit land, it is not identifiable. Further, Mrs. Roy and Co. and another versus so-and-so, reported in 1979, Calcutta 50, it was held that the case of conflict between area and boundary, the description of boundary will prevail. Under the backdrop of the factual and legal position, I am of the considered opinion that even if there was transfer of land measuring 1 kotha 5 lakhs pertaining to Dag number 67 and Patta number 25, the said transfer took place merely on pen and paper without the land being specifically identified. For the said reason, after a lapse of 10 years from the date of execution of the first sale deed, the purchasers, including the plaintiff respondent, have to rectify their boundaries just to establish their right over a plot of land covered by the disputed Dag and Patta by way of citing a common boundary. Hence, it is found that even if there are sale deeds and Patta issued in the name of the plaintiff respondent, but those deeds, in absence of proper demarcation of the land under the sale, cannot confer right title to the plaintiff respondent and his vendor over the suit land, which is apparently not shown in the sale deed of the plaintiff respondent as well as his vendor. Hence, the issue is decided against the plaintiff respondent. Issue number 2 and 3, whether the plaintiff's vendor had delivered possession of the suit land to the plaintiff, whether the plaintiff has been dispossessed by the defendant. Now, on perusal of Exhibit 1, Chitha of the year 1974-86, reveals that there are 8 tenants under landlord Dandiram Kumar and Roheshwar Kumar, and Khatian number 52 was prepared under Assam Temporary Settled Areas Tenancy Act. As per Section 6 of the Act, an occupancy tenant have permanent, heritable, and transferable right of use and occupancy in the land of his occupancy holding. As per section 7 of the Act, on the death of the tenant, right of the immovable property descends in the same manner as other immovable property. A tenant gets protection from ejectment except as provided under chapter 9 of the Act. In the case in hand, from Exhibit 1, the chitta, it is apparent that there are 8 occupancy tenants over the entire land. Hence, unless it has been shown that the tenancy has forfeited in compliance with section 50 of the Act, it is to be presumed that the land under the disputed dung is still in occupation of the tenants. Moreover, it is the duty of the plaintiff to prove that the suit is presently not under khatiyan or that the tenancy has been forfeited, complying due procedure of law, but no any steps have been taken by the plaintiff. Pleadings of the plaintiff is surreptitiously silent regarding the status of the tenant whose possession reveals to be more than 36 years old from the year 1973, that is the date of endorsement on the chitta, till filing of the suit in the year 2009. That being the possession, it is held that the plaintiff has failed to prove possession of the original pattadar, not to speak of his own possession over the land covered by Act number 25. That besides the plaintiff's pleading is also silent about the date of dispossession. Now, very quickly, my lord, date of dispossession is his dispossession from the suit land. Now, just for convenience, for a moment, if your lordship turns to page 18, there is a clear the specific date of dispossession in the cause of action column.
Page number 18.
18. Just to show that this was not.
Yes.
On 4/4 to the para 11, this was introduced by way of an amendment. So perhaps the amended plaint was not seen. Anyway, coming back to page 95 now.
Yes.
Para 37. Record reveals that suit was filed on 21/3/2009. An amendment application to insert the fact of alleged dispossession was filed immediately after 1 year from the filing of the suit. Situated thus, even if it is presumed that during pendency of the suit, 1 year of the date of application, plaintiff was dispossessed, then it was a new event which could have been narrated by the plaintiff precisely with date in as much as time of dispossession as it relates to the subject matter of a suit, which is sub judice before a court of law. Hence, omission to mention the date of dispossession gives rise to probability that the incident of dispossession is not true. Hence, it is held that the plaintiff has failed to prove his dispossession from the suit land. The submission of the learned counsel for the plaintiff respondent, the defendant had failed to prove that he and his predecessor in interest was recorded pattadar of the suit land, whereas plaintiff has proved his title on the basis of chitta and the subsequent registered sale deeds, as well as the patta issued in his name, and as such entitled for a decree is not found acceptable because of the fact that his source of title flows from Exhibit 1 through Exhibit 3, sale deed executed by a defective power of attorney, Exhibit 2. Moreover, the rectification of the boundary was also done without any lawful authority. That besides, in terms of section 101, one who seeks declaration of right title and interest is duty bound to prove his case irrespective of the case of the defendant. It was held by the Honorable Supreme Court in Gurunath Manohar Pavaskar versus others versus Nagesh Siddhappa Navalan and others reported in so-and-so that the burden of proof is on the plaintiff to prove his right title and interest. He can't take advantage of the weakness of the case of self-report by the defendant. That being the position, observations of the learned trial court that the defendant has failed to disprove the title of the plaintiff is not found as per law under the facts and circumstances of the present case. More so, it is settled law that revenue records alone cannot confer title. It should be decided on appreciation of evidence. In view of the above, it is held that the plaintiff respondent has failed to show that he was delivered possession by his vendor and was subsequently dispossessed by the appellant defendant. These two issues are accordingly decided against the plaintiff respondent. Now, last issue is not necessary because ultimately I was held to be not entitled to any. So the basic ground for dismissal of the suit, as can be seen from the appellate judgment, is that number one, the power of attorney holder, the general power of attorney did not contain a schedule, number one. Number two, they say that the rectification was done after the execution of the original sale deeds. There was delay in doing the rectification. Number three, it was held that I could not prove possession because the land was from the chitta appeared to be in possession of tenants. However, the case of the defendants was not at all discussed on the ground that I am the plaintiff, so I am required to stand on my own leg. Now, for a moment, if I may take your lordship to page 58, the findings of the trial court. Para 13 minutes. The plaintiff in his plain has pleaded that he bought the suit land from Shri Subhash Chandra Das. Shri Subhash Chandra Das, with a view to sell his land, executed power of attorney being deed number so and so in favor of one Suman Das Gupta, empowering him to sell his land, measuring 1 kotha 5 lacham. As the boundary given in the said power of attorney was wrongly shown earlier, a deed of rectification being deed number so and so dated 18/7/2008 was executed. The said Shri Suman Das Gupta, being the attorney of Shri Subhash Chandra Das, ultimately sold the aforesaid 1 kotha 5 lachas of land to the plaintiff by executing a registered deed of sale bearing deed number so and so dated 17/12/2007. As the defect of the boundary was detected later on, a deed of rectification deed number 11048 dated 18/8/2008 was executed by inserting the present boundary of the aforesaid sale deed to correct the boundary of the aforesaid sale deed. The land purchased by the plaintiff, namely Abhishek Shah, measuring about 1 kotha 5 lachas, covered by DAG number 67 old 1999 new of KP Patta number 25 139 old 830 new of village Jotikusi under Moza Beltola in the district of Kamrup. The name of the earlier vendor Ravi Paul and all other subsequent purchasers in respect of the suit land were duly mutated, confirming their possession. They have been paying the land revenue in respect of the suit land. During the settlement operation, a certificate has been issued by the settlement office confirming mutation in the name of Abhishek Shah. The plaintiff has been possessing the suit land continuously by paying land revenue. It is further pleaded that late Dondiram Kumar and Roheswar Kumar were the exclusive owner and possessor of the total land covered by Patta number 25. After disposal of land by various manner, a portion of land measuring 3 bigha 4 kotha 7.5 lachas remained in the hands of Ananta Kumar, son of Dondiram Kumar, and Sri Arun Kumar and Jagdish Kumar, both sons of Roheswar Kumar. With a view to dispose of the aforesaid 3 bigha 4 kotha 7.5 lachas of land, Ananta Kumar, Arun Kumar, and Jagdish Kumar jointly executed a power of attorney, appointing and empowering Sri Ranjit Kumar Day, son of Dakharat Kumar Day, being deed number so and so dated 16/10/1996. By this power of attorney, Ranjit Kumar Day was duly authorized to sell the above 3 bighas 4 kotha 7.5 lachas of land. Sri Ranjit Kumar Day, on the strength of the aforesaid power of attorney, being deed number so and so dated 16/10/1996, ultimately sold 1 kotha 5 lachas of land out of the aforesaid land to Robbie Paul by executing a registered deed of sale bearing 3421 1998 and 23/6/1998. The said attorney Sri Ranjit Day, at the time of sale, also delivered possession to Sri Ajit Chandra Day. At the time of the sale, also delivered possession to Rabi Paul upon the land covered by the present boundary, though it was wrongly shown in the aforesaid registered deed of sale. The said Rabi Paul continued his possession upon the land he purchased with the present boundary. PWs have reiterated the same facts in their examination in chief. The said Rabi Paul, after peacefully possessing the land for about 6 years, ultimately sold the same to Subhash Chandra Das by executing a registered deed of sale being number so and so dated 3/8/2004 and also delivered possession to Sri Subhash Chandra Das. The said Sri Subhash Chandra Das, after purchasing the land, kept the same exclusively under his possession for about 2 years. From Sri Subhash Chandra Das, the plaintiff bought this land as aforesaid. In Exhibit 1, that is Rav Chitha, it is mentioned that Dondiram Kumar and Roheshwar Kumar were original pattadars of the land covered by DAG number 67 of Patta number 25 of village Jotikusi. Exhibit 2, that is power of attorney, deed number so and so dated 16/10/1996, executed by Ananto, Arun, and Jagdish Kumar, the legal heirs of and heirs and successor of Dondiram Kumar and Rahashwar Kumar, whereby Ranjit Kumar Dev was authorized to sell land measuring 3 bigha 4 kotha 7.5 lechas. Exhibit 3 is the certified copy of the sale deed 3421 dated 23/6/2008, whereby the power of attorney holder Ranjit Kumar De sold 1 kotha 5 lechas out of the said land to Ravi Paul. Exhibit 7 is the sale deed number 5835/2004 dated 3/8/2004, executed by Ravi Paul in favor of Subhash Chandra Das, from whom the plaintiff purchased the aforesaid suit plot of land. The principal defendant in his written statement has denied all the averments made in the plaint. The principal defendant has denied that Dandir Kumaram Kumar and Raheshwar Kumar were the exclusive owner and possessor of the total land of Patta number 25. It is also alleged that the alleged power of attorney number 5299 dated 16/10/1996 is forged and fabricated. It is also specifically pleaded by the defendant that Subhash Chandra Das did not get any title by alleged transfer by deed number so and so dated 3/8/2004. It is also denied that Subhash Chandra Das was in possession of the land for 2 years. It is also denied that Subhash Chandra Das executed any power of attorney authorizing Suman Das Gupta as claimed. It is also denied that any deed of sale was executed by Suman Das Gupta in favor of the plaintiff. It is denied that possession of the suit land was delivered to the plaintiff at any point of time. All the PWs have been cross-examined by the defendant, but nothing material has been elicited from the cross-examination of the PWs. The official witness of the plaintiff has also proved Exhibit 2, that is the certified copy of the power of attorney, being deed number so-and-so dated 16/10/1996, whereby Ananto Arun and Jagdish Kumar had authorized Ranjit Kumar De to sell the aforesaid 3 bigha 4 kotha 7.5 lechas of land. The relevant volume book has been exhibited as Exhibit 17 by the official witness of the plaintiff. From this particular volume book, the Exhibit 2 was prepared. The aforesaid official witnesses have proved the original sale deed number so and so dated 23/6/1998 as Exhibit 18, whereby Ranjit Kumar De sold 1 kotha 5 lechas of land to Ravi Paul on the strength of the power of attorney. The aforesaid witness has also proved the original deed of rectification of sale deed number so and so is Exhibit 19, that is Exhibit 4 of the PWs, whereby the boundary of the land mentioned in the sale deed dated so and so was rectified. The official witness has also proved that the Exhibit 7, that is the sale deed number 5835/2004 dated 3/8/2004, executed by Ravi Paul in favor of Sri Subhash Chandra Das, from whom the plaintiff bought the suit land. The official witness has exhibited the Exhibit 7 as Exhibit 20. The official witness has also proved Exhibit 9, that is power of attorney, deed number 3152 dated so and so, whereby Sri Subhash Chandra Das authorized Suman Das Gupta to sell the land measuring 1 kotha 5 lecha. The official witness has exhibited the Exhibit 9 as Exhibit 21. The official witness has also proved the Exhibit 10, that is the deed of rectification, being deed number so and so, whereby the boundary of the land mentioned in the said power of attorney was rectified. The official witness has exhibited Exhibit 10 as Exhibit 22. The official witness has also proved Exhibit 11, that is the certified copy of the sale deed dated 17/11/2007, whereby the suit land was sold to the plaintiff. The official witness has also proved the Exhibit 11 as Exhibit 23. The official witness has also proved Exhibit 2, the certified copy of the rectification deed dated 18/8/2008. The official witness exhibited Exhibit 11 as Exhibit 23. In view of the above, it is evident that Suman Das Gupta was the owner of the suit land at the time of selling of the land to the plaintiff. The evidence of the PWs and official witnesses remain uncontroverted. During cross-examination of the aforesaid witness and PWs, nothing material could be elicited from him which goes in favor of the plaintiff. How the vendor of the plaintiff acquired ownership of the suit land has been proved by Exhibit 2, 3, 7, and 8. The vendor of Subhash Chandra Das was the owner of the suit land, which is proved by Exhibit 3, 4, 5, and 6. The vendor of Subhash Chandra Das, namely Ravi Paul, after purchasing the suit land by Exhibit 3 and Exhibit 4, mutated the land in his name, which is proved by Exhibit 5, that is Kacha Patta, showing land revenue in the name of Ravi Paul. Exhibit 6 that is revenue paying certificate also proves that Ravi Paul was regularly paying the revenue. On the other hand, the defendant has denied the ownership of Subhash Chandra Das, yet the defendant has failed to adduce any cogent evidence to prove this fact. On the other hand, DW1 in his examination in chief has deposed that the suit land belongs to him and the plaintiff has got no right, title and interest over the same as claimed by him. DW1 has further deposed that Sunil Kaur, his predecessor in interest and others, who along with Boloram Kaur purchased the plot of land measuring 2 kothas 10 lechas covered by Pata number 25, Dag number 67 with specific boundary. The predecessors in interest, Sunil Kaur and Boloram Kaur, purchased from Dondiram Das, son of Horendranath Das, and Muhammad Anwara Hussain Diwan, son of Sonaullah Diwan, both of Guwahati, while registered sale deed number so and so, dated 4/5/1984 in the office of Sub-Registry Guwahati. The said Dondiram Das and Anwara Hussain purchased the land from Satya Kumar and Narayan Chandra Kumar, both sons of Dhani Ram Kumar of Maligaon, Guwahati. Satya Ram Kumar and Narayan Chandra Kumar purchased the land from one Nandi Ram Kumar, son of late Ganga Ram Kumar of Maligaon, Guwahati, while deed number so and so dated 3/1/1951. The defendant bought the suit land from Boloram Kaur and Sunil Kaur. The sale deed was executed in his favor on 28/3/2005 and registered on the same day in the office of the sub-registrar Panikhaiti Kamrup, Guwahati, by deed number so and so, and delivered possession of the land to the defendant. During cross-examination, the DW1 has deposed that he can't say on going through exhibit A, B, and C as to who bought whose land. DW1 has further deposed that he has not produced the sale deed by which the Dondiram Das and Anwar Hussain bought the suit land. The defendants have failed to prove that at the time of selling of the suit land, Shri Sunil Kaur and Boloram Kaur had ownership over the suit land. In the plaintiff's evidence, there is chronological description as to how the plaintiff's vendor became the owner of the suit land, but in the evidence of the defendant, there is no chronological description as to how the defendant's vendor came into possession of the suit land and owned the suit land. The plaintiff has discharged his evidence by exhibiting Exhibit 1, 2, 3, 4, 5, 6, 7, and 8, which are in chronological order, pointing towards the ownership right of the plaintiff's vendor. On the other hand, the defendants Exhibit A, B, and C are not in sequence, and as such, it is not clear as to how the ownership right of the defendant's vendor was acquired. The defendant has failed to prove as to how the seller in the sale deed, that is Exhibit A, Exhibit B, and Exhibit C, became the owners of the suit land. The vendor of the plaintiff, namely Subhash Chandra Das, became the owner of the suit land while Exhibit 7, that is the sale deed number so and so, dated 3/8/2004. The plea of the defendant is that Exhibit 7 is a fraudulent document, but the defendant has failed to prove this plea by adducing cogent evidence. The mutation of a person in the record of right raises a presumption that he is the owner of the land unless otherwise contrary is proved. Exhibit 1, 5, and 6 prove that the names of the predecessor in interest of the plaintiff's vendor, Dhani Ram Kumar and Raheshwar Kumar Ravi Paul, had ownership right as their names find place in the record of right. The defendant has not rebutted the said presumption by adducing cogent evidence. Hence, Shri Subhash Chandra Das, the vendor of the plaintiff, was the owner of the suit land, and Shri Subhash Chandra Das sold the suit land to the plaintiff through his power of attorney holder, namely Suman Das Gupta. Hence, the issue is decided in favor of the plaintiff. Decision: the plaintiff's vendor had acquired title to the suit property. 2. Whether the plaintiff's vendor had delivered possession of the suit land to the plaintiff. The plaintiff's plea is that Subhash Chandra Das, through the power of attorney Suman Das Gupta, while registered sale deed number so and so, dated 17/11/2007, Exhibit 11, sold the suit land to him. The defect of the boundary in the aforesaid sale deed was rectified later on by deed of rectification dated 18/8/2008 by inserting the present boundary. Before purchasing the land, the plaintiff verified the land records of the suit land, and after satisfying himself that Sri Subhash Chandra Das was in possession of the suit land, he decided to purchase the suit land. After purchasing the suit land, the seller had handed over possession of the suit land to the plaintiff, and he has been possessing the same till the date of dispossession. The plaintiff is able to prove that his name has been mutated over the said land. After completion of the settlement operation, final patta was issued in his name, which is issued in his name, which is evident from Exhibit 13, 14, 15, and 16. On the other hand, all the title deeds submitted by defendant do not disclose any boundary, and as such, it is not ascertained whether the suit land is the same as claimed by the defendant. The defendant has failed to show that his name has been mutated over the suit land. The mutation of a person in the record of right raises a presumption that he is the owner unless otherwise contrary is proved. Defendant has every right to rebut the presumption, but the defendant has failed to rebut the said presumption by adducing cogent evidence. The defendant's submission is that only mutation does not confer ownership right over the property, but the defendant has failed to prove that the plaintiff is not the owner of the suit land. The plaintiff has discharged his burden by adducing Exhibit 13, 14, 15, and 16. These are the pattas. The defendant has himself failed to prove that he is the owner of the suit land. The plaintiff has exhibited the mutation certificate, periodic patta, draft jama bondi, and the sale deeds before the courts to prove his ownership and possessory right over the suit land. The other PWs have also corroborated the facts of the plaintiff that the plaintiff was in possession of the suit land. The defendant has failed to exhibit any document of record of rights to prove that he is the recorded pattadar of the suit land. During cross-examination, the DW1 has deposed that the boundary of the land mentioned in Exhibit D and the boundary of the suit land is completely different from each other. During his cross-examination, DW1 has admitted that till date, he has not got the patta of the suit land. In his cross-examination, DW1 has deposed that the suit land was sold in the year 1998 by Ananto Ram, Arun Kumar, and Jagdish Kumar through their power of attorney holder Ranjit Kumar De. On the other hand, the defendant purchased the suit land in the year 2005. Therefore, the suit land was purchased by Ravi Paul prior to purchasing the suit land by the defendant, from whom Subhash Chandra Das bought the land. Sri Ravi Paul, after purchasing the suit land, kept the same under his possession for about 6 years. His name was also mutated in respect of the said land, which confirms his possession, and as such, Ravi Paul was recorded pattadar of the suit land in the year 2004. Therefore, Sri Ravi Paul had saleable right from whom Subhash Chandra Das bought the suit land on 3/8/2004. Therefore, Subhash Chandra Das sold the suit land to the plaintiff on 17/11/2017 after keeping the same under his possession for 2 years. The vendors of the defendant was never the recorded pattadar of the suit land. The vendors of the defendant were never the recorded pattadar of the suit land during that period, and as such, Bolaram Kaur and Sunil Kaur had no saleable right over the suit plot of land. As such, the suit land transferred in the year 2004 by Ravi Paul to Subhash Chandra Das. Sri Subhash Chandra Das had saleable right in the year 2005. In his cross-examination, DW1 has admitted that the boundary of the land purchased by the plaintiff and the boundary of the land purchased by him is completely different from each other. In view of the above, the issue is decided in affirmative and in favor of the plaintiff. So it was held that plaintiff's vendor had delivered possession of the suit land to the plaintiff. Whether the plaintiff has been dispossessed by the plaintiff. It is pleaded a fact of the plaintiff that he was in peaceful physical possession of the suit land till the date of dispossession. The plaintiff has further pleaded the defendant has illegally dispossessed him from the suit land. The defendant in his written statement has pleaded that he constructed rooms on the suit plot of land and started living thereon with his family members, including sister, brother-in-law, nephew, and also given on rent to tenant. The defendant applied for GMC holding, which was granted to him, being holding number so-and-so, ward number so-and-so, dated so-and-so, and the defendant is paying tax regularly. Hence, it is proved that the plaintiff has been dispossessed by the defendant. Now, regarding the faction of dispossession, my lord finds the plaint at page 12. Initially, it was not filed for recovery of possession at all. Page 16, if your lordship takes up, the dispossession happened subsequently, and therefore an amendment had to be introduced. 8.1, that the plaintiff begs to state that along with the plaint, he also filed an application under Order 39, Rule 1 and 2, read with Section 151 of the CPC for grant of temporary injunction. The Honorable Court was pleased to grant an ex parte ad interim injunction after having heard the learned advocate for the plaintiff by his order dated 25/3/2009. The plaintiff in this regard begs to make it clear that though the defendant has been illegally claiming the suit land to be his own, yet he was never in possession of the suit land. but the defendant immediately after granting of ad interim temporary injunction in favor of the plaintiff petitioner, just to show his possession in a most illegal and arbitrary manner, forcibly entered upon the suit land with the help of some hired ladies and took possession of the same through those ladies. Though the plaintiff informed the police about the illegal dispossession by the defendant by filing an FIR, but the police, due to pendency of the civil suit, did not take any steps. The plaintiff begs to state submit that due to the aforesaid illegal action of the defendant, the plaintiff is a law-abiding citizen and had to lose his possession over the suit land, and ultimately he has left no alternative but to pray before this honorable court for a decree of recovery of khas possession and vacant possession of the suit land from the illegal possession of the defendants. The plaintiff begs to submit that as the defendant in a most illegal and arbitrary manner forcefully took possession of the suit land from the plaintiff during pendency of the present suit, from his conduct and character, it is apparent the defendant may also try to take possession of the suit land even after disposal of the aforementioned above noted suit. Hence, it is a fit case where this honorable court may be pleased to declare the suit, decree the suit for permanent injunction restraining the defendant, his men, agents, and servants from entering upon the suit land, more fully described in the schedule to the plaintiff, and also restraining him from disturbing the peaceful possession of the plaintiff, so that the plaintiff would be able to enjoy his property in future. And thereafter, at para 11 on the following page, Malon, the specific dates were given: 14/3/2008. When the plaintiff started construction of the boundary wall, on 17/3/2008, when the defendant started disturbing the work, and on 4/4/2009, when the plaintiff was illegally and forcefully dispossessed by the defendant from the suit land, and on each and every subsequent date thereof. Accordingly, my lord, para 1A was added at page 19 for recovery of possession. Now, my lord, now, first of all, my lord, insofar as perversity is concerned, one of the grounds for interference with the trial court judgment was that the factum of dispossession was not really proved, and the First Appellate Court went on to hold that the date of dispossession itself was not pleaded. That is something which is contrary to record, and therefore I would say that non-consideration of the pleadings in the proper perspective would tantamount to perversity, because a specific date of dispossession was clearly alleged in the claim. The date, of course, was during pendency, which is why it had to be introduced by way of an amendment.
So, whether any issue, no, substantial question of law is framed on this point?
Yes,
Perversity?
yes. It should be substantial question of law number 3, Manoj. Substantial question of law number 3, it says, reads as whether the findings recorded by the First Appellate Court holding that there was omission to mention the date of dispossession is contrary to pleadings on record, more particularly the amended claim. Now, 4 is also, I'll just give the outline and close, Manoj, very quickly. Now, Manoj, possession, Manoj, the First Appellate Court stressed a lot on possession, Manoj, but it had ignored the fact that this was not a suit based on previous possession at all. since it's a suit based on title, my lord, the moment I prove title, possession should follow title, and therefore the factum of dispossession, etc., may perhaps lose significance, considering the fact that it's a suit based on title and not based on previous possession, my lord. Which is why we had the fourth substantial question of law was formulated, my lord. Now, insofar as the deed of rectifications are concerned, my lord, now the First Appellate Court held that on the basis of the power of attorney, the sale deeds were executed, that is fine. But what gave authority to the constituted attorney to again correct carry out the rectification or execute the rectification deeds? Now, for that, my lord, I'll refer to that exhibit 2, which is the power of attorney on the next date, my lord. It clearly says that the power of attorney is entitled to execute any deed that may be required. Now, when it says any deed, does it not naturally mean that post the execution of the sale deed also there can be a rectification deed on the basis of the same powers which are vested through that power of attorney? Then
no, any deed is mentioned
in the power of attorney.
Power of attorney.
Yes. Now, perhaps what the learned First Appellate Court wanted to convey was that power of attorney is for execution of the sale deed. That sale deed is already executed.
Not for rectification.
Not for rectification. But it had omnibus powers, and I'll show from that exhibit that it was any deed, instrument, document, the power of attorney can, the constituted attorney can execute. So therefore, those wide powers would also naturally include the right of executing a deed of rectification. And lastly, my lord, the court held that the rectification deeds are so much later in the point of time, and therefore they are not believable. Now, to that, our argument would be that there cannot be any specific time frame within which an instrument is required to be rectified. Lord, I'll elaborate on these questions.
Next that.
Yes,
You suggested that convenient to both of you?
December no. By a hypothetical piece of money. Hypothetical piece of
19, 12,
November?
December.
19 December. Okay. Then put
19 December.
19, Mr. Decker, on that is the last week.
No, last working day.
So it may be fixed for motion only.
Before vacation, my lord.
Because yes, is right. It could be then 12. The other matter was fixed therefore.
12 December.
12. Let it be, my lord, 12 or 13. 12 being Thursday, my lord. 12.
There's another few matters fixed for as one.
But let us see, because we cannot anticipate what is going to happen on that very day.
Okay.
So practically, my lord, 12 of 12. 12.
Heard Mr. B.P. Decker, learned counsel for the appellant, and Mr. Sutter, learned counsel for the respondent number.
I'm one man.
Sol.
Yes.
Four parties.
Abhishek, sir.
No, several respondents are there.
My lord, I am for respondent number.
All the respondents. Okay. Heard in part, list the matter on 12 December as part heard.
Yes, my lord.
Item 38 for this.
Hold
for this-
30 and 31 will remain together.
Order taken.
Is your answer. And if there was the office order But officer, we have taken the steps also, no, earlier, at the same time, notice has been issued. So, but the office order has not been updated till now. So.
Whether served or not, notice.
So that is the concern. We have already, steps have been taken. But service has been completed or not, the office order has not been updated. So matter will be placed before the laws for verification of the completion of service.
Okay. Heard, Mr.
S.A. Bakhtiar.
S.A. Bakhtiar, learned counsel for the appellant.
Appellant.
Justice shall list the matter before Lawzima court to ascertain whether notice upon the respondent will. How many respondents are there?
Respondent one has been already been done, but two service has been awaited.
Respondent number two. Service upon respondent number two was effected or not?
32 for hearing. 32.
Maybe Mr. Lordship.
31, 32 same it.
31, 32 submitted.
39.
Maybe Mr. Lordship kindly pass it for the list. My son is out of focus.
As agreed by learned advocates of both the parties, justice shall list the matter.
Shipa date may be fixed. 7th of November or 12th.
No, last part of November.
26th November.
But this matter is in hearing column.
Yes, Your Lordship, 26th November.
But
is-
why you have mentioned it as order column?
The petitioner has mentioned.
Who had mentioned the matter?
We have mentioned the matter, Your Lordship, for hearing.
Then why? No, it has been. You see this mention memo. Don't do it in future.